and he has no objection to the prayer made by the learned counsel for the petitioner. Stop. Huh? Accordingly, this list is matter on 21st. 23rd January 2024. Huh? Okay.
I need to mention item number 6.
6.
On the last occasion, the court instructed the parties to sit down
Okay.
together and sort out the matter. They have sat down and the meeting was inconclusive. So
Okay.
they are again sitting down together in the second week of December.
Okay.
So let it be listed in the third week of December.
Okay. You are for petitioner.
For the petition.
Okay. And for the other side?
It's a.
Okay. Mr.
City on behalf of Bandan Nukan.
appearing on behalf of Mr. Bendan Nukan, learned counsel for the petitioner, prays that this matter may be listed for
Third week of December.
okay on third week of the December stuff. The prayer is allowed. List the matter on third week accordingly. Huh? Okay.
14th. December 14th.
December 14th. It's a fixed item. Why? The party has not yet decided on the process.
They will be sitting in the second week of December.
Okay. Okay. List the matter on 14th for admission. Okay.
Much obliged.
Yeah, please, Lordship. Lordship, I think the mention item number 11, Lordship. On behalf of the council for the petitioner to be polled. Lordship, I pray that this matter may come up on date 14, Lordship. We have taken the consent from the other parties.
14.
Yes, Lordship.
Okay. Mr.
Medovero, Lordship. On behalf of the
Sorry.
poll.
Medovero
Yes, Lordship.
appearing on behalf of Mr.
PB poll.
P.V. Paul.
Yes.
You are for the other side.
Yes,
Respondent number? All. Or how many respondents?
All the respondents.
Okay. On behalf of Mr. You are praying on behalf of,
Mr. PB poll, Lordship.
okay. Paul, huh?
Yes.
Prays that the matter may be listed on
14th of December.
14th
Yes.
of December for hearing. To which Miss, you are Miss?
Miss Catherine Anisha.
Appearing on behalf of the respondent has no objection. So accordingly, the prayer is allowed. List this matter on 14th
Yes.
for hearing. Okay.
Obligement.
May I please, Lordship?
Yes.
Lordship, I beg to mention item 6, Lordship.
6 already mentioned, I think.
Item 9,
9.
item 9, yes.
Okay.
I pray that this matter pass over for the.
Okay.
Yeah.
And then you are for?
Lordship, I'm moving of the council for the petitioner, Mr. PB poll, Lordship.
Okay.
This matter can be fixed on, come up on next week, Lordship.
Next week, next week.
Next week, Monday, Lordship.
Is prayed for by Mr.
Visual.
Jamomi. You are for respond? PP.
Respond.
Okay. Lara PP. And Mr.
Medovero.
Medovero,
Yes.
Lara counsel for the
Petitioner.
revision petitioner. List this matter
Next week, Lordship.
next week for admission.
Lordship,
Okay.
interim, Lordship.
In the meantime, the interim order passed earlier shall continue.
Deputy obliged, Lord.
For motion, item number 1.
Yeah, please, Your Lordship.
Yes.
Lordship, this is a contempt petition
Hmm.
for filed for non-compliance of order dated 29/11/2022 passed in WBC number 185 of 2019.
Okay,
Your Lordship, let me take you to the order, relevant portion of the order. It's
okay, please.
page 91. Starts from para 34.
Yes,
This is the relevant portion. Considering the above, this court therefore disposes of the instant repetition with the following observations and corrections. There are 6 observations.
Mm,
1, the court declares that the action of the deputy commissioner to enlarge the width of the road reserved to 27 meters, that is 13.5 meters from the center of the stretch of the road, that is NH 39 from 110 to 123 kilometer section of the highway from Timapur to Chumukirma without hearing of any acquisition, and more particularly the notification dated 28/4/1999. Consequently, stands vitiated for not following the due process. The landowners whose land falls within 13.5 meters from the center of the road in the said stretch of road, if affected, would be entitled to compensation as mandated under law. The second direction was taking into account that this court is not in a position to decide how much and which land of each of the petitioners or any of the landowners have been affected. It would require a fact-finding inquiry. This court directs the petitioners to submit their claims, including their claims for destruction of the properties, along with their land documents and other documents for verifications before the Deputy Commissioner Timapur and or Deputy Commissioner Chumukiteba, before whose jurisdiction their land falls within 45 days from the date of the instant order. Taking into account that only 230 petitioners had filed the instant writ petition, and there may be other landowners who may have been affected, this court further directs the Deputy Commissioner Timapur as well as the Deputy Commissioner Chumukiteba to issue a notice in a news daily of wide circulation, calling for any claims along with their documents for verification. The same should be done within 20 days from the date of the instant order. In the next page, the third direction, on the basis of the claims as well as the documents so submitted, the Deputy Commissioner Timapur and or Deputy Commissioner Chumukiteba and or any other person to whom the Deputy Commissioner deems fit to entrust, but not below the rank of an additional Deputy Commissioner, shall verify the said claims on the basis of the documents submitted within a period of 6 months from the date of submission of the claims by the persons interested. In filing said claims, the petitioners as well as the landowners will be at liberty to also submit claims regarding their loss suffered on account of demolition of their properties. Fourth direction, upon verification, if it is found that the petitioners or landowners have been affected on account of enlarging the width of NH 39, that is the 27 meters, that is 13.5 meters from the center of the road in the stretch of road, that is NH 39, from 110 kilometers to 123 kilometers, section of the highway from Timapur to Chumukiteba, then in that case, the Deputy Commissioner Timapur and or Deputy Commissioner Chumukiteba, in consultation with the state of Nagaland as well as the respondent number 2, shall initiate proceedings for acquisition under the National Highways Act 1956 by following the due process. Fifth direction, it is made clear that if in the circumstances, the petitioners and or the landowners are aggrieved by the fact-finding inquiry by the Office of the Deputy Commissioner, the petitioners and or the landowners would be at liberty to initiate proceedings under the Code of Civil Procedure 1908. And the next page, the sixth direction, if the petitioners, however, are aggrieved by the actions of the respondent authorities in respect to entitlement and quantum of compensation, the petitioners can avail the remedies available under the National Highways Act 1956. So this was the direction. So accordingly, the petitioners have submitted representations as per the directions to the Deputy Commissioner in the directions. And then based on that, as per the directions, they have circulated in the newspaper also.
okay,
However, till now, the direction was to complete within 60 days for the compensation or the amount of compensation or to ascertain whoever is entitled for compensation. However, till date, it has not been done by the concerned respondent authorities. That's why we have filed this contempt petition.
so they have partially complied.
Partially complied. And your lordship is well aware that as per the orders of the apex court, partial compliance is not compliance in contempt proceedings. So at this stage, if.
So when the order, when this order was passed,
29/11/2022. 29/11/2022.
okay. 11,
Yes, 29 November.
okay. So yesterday expired 1 year.
Yes, we have filed on
When
Friday.
we filed it?
Friday, we have filed.
Okay. Before expiry,
Yes,
before 1 year. This notice,
yes, Lordship.
the petitioner. How many petitioners are there?
There are 226.
Okay, 226 numbers. File this application under section 11 and 12 of the Contempt of Court Act 1971. Read with Contempt of Court, Gauhati High Court, Rules 1977, and Article 215 of the Constitution of India. Against, how many respondents are there? Against,
8 respondents.
against
8
the
respondents.
respondents, within bracket, alleged contemptor. For where is your prayer portion? Page,
The order is page 40, annexure A.
with the judgment.
CDC is next. Order dated 29/11/2022.
Okay.
Annexure A, page 40 is the
Page 40.
40 is the judgment of the.
Okay. Respondent for deliberate and willful violation
Yes, Lordship.
of the judgment and order,
Violation and non-compliance, Lordship.
violation and non-compliance of the judgment and order. This
Dated
is order dated 29,
11/11/2022.
29/11/2022, passed in
WBC 185.
WPC 185, 2019. Stop, Dana counsel for the petitioner. Issue notice upon the respondents returnable by 4 weeks.
4 weeks.
Stop. The petitioner shall take steps upon the respondent by a registered post with ID card within
Since tomorrow is a holiday, five days.
within 5 days.
Yes, Lordship.
Stop. List is after. List is matter after 4 weeks. Okay.
Much obliged.
For motion, item number 2.
Mr. Lordship. Lordship, this contempt petition is filed for non-compliance of this on report dated 24/4/2023 in WPC 256 of 2021, Lordship. Lordship had this court dispose of with the writ petition with the direction to release the salaries of the petitioner for services rendered and also to reappoint the petitioner by applying the same yardstick, Lordship. However, till that state respondent has not yet complied, Lordship. So this petition,
Order was passed on
Order was on
24.
24, yes, Lordship.
24/4.
Yes, annexure, the annexure three.
Let's see the direction, just let's see the
The-
operative portion.
Lordship, the relevant portion is at page 23, para 10, Lordship.
Yes. Let us read.
May I read, Lordship?
Yes, please.
In view of the above, this court finds that since the petitioner is entitled to be paid for the services rendered, either by way of the extension of our services with, which was last extended till 31/3/2017, up to the date, up to the date her services have been utilized by the state respondent and accordingly pay the salary due to the petitioner, or the state respondent may also consider the reappointment of the petitioner to the same post of the medical attendant, JK subcenter under the CMO Dimapur, as per the letter dated 8/3/2021, by applying the same yardstick as applied to the similar situated person, namely Asanga Samtampuj.
Okay.
Lordship, we have also served the government letter on the 4th of May 2022, that is election, we have also annexed,
And it's the page.
page 25. Lordship.
So there is no specified date to be for compliance of the order,
Lordship, there is no time frame, Lordship.
No
However, it's
time frame.
almost 7 years, Lordship.
and then you have submitted this order
Lordship,
the-
on the 4th
responded on 4th of
May, Lordship,
May. Okay, so thereafter no reply,
Lordship.
and
In fact, Lordship, this is the this week was the second round of litigation, Lordship.
okay,
Lordship.
what was the consequences of the first round of
Lordship, even in the first petition, there is honorable court directed the state government to consider her representation.
not considered.
However, yes,
Okay, this is second round,
Lordship.
and then thereafter, after this 4th May, have you approached again or
Lordship, she
by
has been.
reminder?
Yes, Lordship, she has been approaching personally, however, till that, no, outcome has been.
Hmm. Okay. Uh, Your good name?
Mika
Doctor.
H. Lordship.
Hmm?
Mika H.
Okay. And counsel for the petitioner, huh? The petitioner filed this application under section, I think it's same notice, no? Section 11 and 12 of the Contempt of Court Act 1971, read with the article just a minute. Okay, read with Article 215 of the Constitution of India and the rules of this honorable, the High Court for initiation of the contempt proceeding. For non-compliance of the order dated 24/4/2023, passed in WPC number 256/2021. Stop, huh? Issue notice on the respondent, issue notice returnable by 4 weeks. Stop. The petitioner should take steps upon the respondent within 5 days. How many respondent?
3, Lordship.
3. 5 days by a registered post with ID card. So list this matter after 4 weeks. Okay.
Much obliged.
For motion, item number 3.
This your lordship. This prison IA has been filed for seeking confirmation of 150 days delay
Okay.
in filing of the restoration petition
Hmm.
against the order which was passed by the this honorable court on 26/5/2023,
Hmm.
where the criminal appeal number 3 of 2021 was dismissed for non-prosecution.
Okay.
So, my lord, IA has been filed, this prison IA, seeking for compensation of 150 days delay to condone and to restore the criminal appeal which has been dismissed by this honorable court by
Okay.
order 26/5/2023.
So we issue notice
Yes,
in condemnation petition first. Okay. The petitioner file application under section 5 of the Limitation Act 1963, praying for condonation of delay of how many days?
100.
150 days in filing connected restoration petition,
Yes, my lord.
restoration petition, which was dismissed.
By order dated 26/5/2023,
Okay, which was dismissed on
non-prosecution,
on which date?
26/5/2023.
26/5/2023. For non-prosecution. Stop, huh? Hard line counsel for the applicant. You are for,
CPI,
okay. What do you call it? Standing counsel?
Pentam Wapang,
Hmm.
Pentam Wapang.
Pentam Wapang. What do we call standing counsel for CBI, or what do we call?
Yes, standing counsel as well as special counsel.
Okay,
Special
special counsel, okay. For the CBI. So issue notice upon the respondent returnable by
4 weeks.
4 weeks. Stop. Huh? The petitioner should take steps upon the respondent. They are also a private respondent also.
Yes, my lord.
Okay, by a registered post with ID card. Stop. Huh? Within ID card within 5 days. Same. Huh? Para list this matter after 4 weeks. Okay.
For motion, item number 4.
Thank you, your lordship.
Yes.
Lordship, I filed this application under 482, Red Wit 401 and 397 CRPC. Pertaining the impugned order by which my Zima application had been rejected by the Internet Special Judge Kohima. Lordship. And therefore, I'm before my lord with this application. Lordship, I am a army personnel and I am the owner of the truck, the vehicle in question in this particular case. And because I presently posted in Imphal, Manipur, I'm unable to drive this vehicle personally. And therefore, I have employed one person by the name CP Davilini as my driver. And it is the case of the prosecution that on 27th 9/2023, when the vehicle was proceeding from Senapati to Dimapur to carry sand, the excise personnel had intercepted the vehicle at the interstate checkgate, where 500 grams of heroin was allegedly recovered from the vehicle. And during such time, the occupants of the vehicle, the driver and one handyman, they have been arrested. And Consequently, as a consequence, my vehicle was also seized, and that is how my vehicle has come under the custody of the Excise Personal Service Act. Lordship, therefore, I filed one application for Zima before the learned special judge. However, it was rejected on the ground that more time ought to be given to the investigating agency by the order dated 11 October 2023. Lordship, and therefore, I've waited for 1 month, and I filed another application asking that the vehicle may be released to me on Zima. However, by the impugned order 8 November 2023, Lordship, the impugned order was passed, and the grounds on which my application was not considered, Lordship, I'm aggrieved with that, and therefore, since no purpose is being served by my vehicle remaining stationary within the premises of the excise personnel without maintenance, Lordship, subject to depreciation, I'm before the Lordship with this application.
What is the reason for rejection of your second application for?
Lordship, the grounds on which the impugned order, Lordship, is at page 27.
Yes.
Lordship,
Yes.
the grounds is that the vehicle is supposedly an FIR is supposedly registered against my vehicle. Lordship, I completely deny this. No FIR number.
Which
no-
one? Which one?
My lord, page 28, the last paragraph.
Okay,
Kindly permit me to read this.
please.
On perusal of the status report dated 6/11/23, it is seen that the report of the RTO reveals that the seized vehicle has been blacklisted by the enforcement agency for an FIR being registered against the vehicle on 20 July 23. Lordship, this is something I am agreed with. Lordship, as far as my knowledge is concerned, I deny this, Lordship. During the time of hearing also, I had asked the prosecutor as well as the court to apprise me of under what section, which police station an FIR has been registered. But Lordship, I was not made privy to this supposed FIR that is against me. Also, Lordship, the petition on appearing before the IO has failed to produce vehicle documents. Lordship, I was never directed to produce any documents. Insofar as my knowledge is concerned, I was summoned via telephone, Lordship, and I appeared, to give complete cooperation to the investigation, I've appeared before the IO, and my statement, my name, my data was recorded. I was asked how I procured the vehicle. Lordship, I have given my full cooperation, but on the date of hearing, on Lordship, particularly 8/11/23, the impugned order, on this date, I was surprised that these allegations were made by the prosecutor through the IO, Lordship, and these were the grounds on which my Zima was rejected, Lordship, and therefore being aggrieved,
So the incident took place.
Lordship.
Your vehicle was seized on which date?
Lordship, my vehicle was seized on 27 September 2023. The FIR is at page 14, Lordship. Page 14.
Okay, and case registered under what section?
Lordship, the case is registered under 21C, that is for possession of
C.
yes, Lordship, and stroke section 60, that is also questionable, Lordship. Section 60 of the procedure of law, it is not a compensable offense, therefore, Lordship, insofar as the CRPC is concerned.
21C NDPS.
Yes, my lord, yes,
So this is commercial
yes,
quantity.
yes.
Okay. And so then, okay, so rejected saying that the matter is still under investigation.
Lordship, and that I have not complied with investigation, and that there is some FIR against my vehicle, Lordship. These are things that are unknown to me.
So this is revision petition.
My lord.
Will issue notice? So, yeah, okay. Accept notice, lodge.
My lord, if Lordship may kindly consider calling for LCR also.
Okay. So this record need to be called here. It's of course the Jima petition only.
Lordship, actually, of course, I'm not privy to the contents of the case area, but as far as my knowledge is concerned, on the date of hearing,
Okay,
no case area was produced, a report was filed before the court.
okay,
Therefore, my lord may need to peruse that particular report also to, in hearing.
report is the case, report. Yes.
Yes, a report by the IO pertaining to the vehicles.
What? Then it is a case diary or case report?
It was called the report, so I don't know if the entire case diary was sent or not, but a report was sent. So that.
A report was submitted to the trial court.
Yes, ma'am.
Okay, then it should be available with the court.
Yes, ma'am.
Which court? Special court.
Special court. Kohima.
Okay. Hardline counsel for the petitioner, Mr.
Alezukiri.
Mr. Okay. And also Mr. Ngami. Line PP, na?
Lodge.
Staff, huh? Para. The petitioner filed this, the petitioner by filing this revision petition under section 482 of the Code of Criminal Procedure. So rare weight 401, so,
Yes.
okay. Rare weight section 401 and 397 of the Code of Criminal Procedure challenged the impugn order, which one? Dated
11/20/2023.
11/10, sorry, 8/11.
Yes, my lord.
Challenge the impugn order dated 8/11/2023,
8/11/2023,
passed by the learned special judge NDPS at Kohima, Nagaland, by which the application
Lordship.
by which the application of the petitioner for release of, what is the name, release of the
Release of the
Vehicle
vehicle, Lord,
number?
bearing,
release of his vehicle, what vehicle it is?
it is a truck, Lordship.
Vehicle within bracket truck
And
bearing registration number NL 07 AA 1688 was on Jimma was rejected. No, release of the vehicle on Jimma was rejected. Stop. The case of the petitioner is that the said vehicle was seized in connection with
connection
which
with,
case?
Lordship,
Seized by the police or whom?
Lordship, excise.
Excise officer.
Yes.
What do we call
personnel.
excise personnel?
Yes, my lord. That,
Excise personnel in connection with,
case number.
this is special case.
Lordship,
In
it is in
connection
the
with-
synopsis, first para, excise case number NECKND-05.
Okay, seized by excise personnel,
Yes, ma'am.
in connection with excise case number NEC stroke K stroke ND dash 05 stroke 23. On which date?
Lordship,
27,
date of FIR, what date?
seized.
Seizure is on 27 September 2023.
Okay.
It is, FIR is at page 14.
In connection with excess on 27/9/2023. On the for on the allegation that narcotic substance has been recovered from the said truck. Okay, stop, Issue notice. Returnable by 4 weeks.
Lordship, if I may be given a date of hearing before vacation, I beseech my to consider my prayer.
Before vacation,
Yes, my lord. December 13, Lordship.
Just a minute, sir. Respondent, how many respondents are there? Only state.
Yes, the state.
Is it possible?
Lordship, I don't think it will be possible.
My lord,
Hmm.
the excise station is just in Kohima, 30 minutes away. Lordship, LCR is just here, and also Lordship is too well aware. CD is something that is opened and maintained from date the FIR is registered. So Lordship, why will it not be possible for the prosecution to produce against it?
Initially, then the call for record, huh? Call for records, issue notice upon the respondent. Returnable by 3 weeks then,
2 weeks, Lordship. Court will be on vacation by then. I beseech my.
2
lord.
weeks, will it be possible?
We'll make it in the.
Okay, we'll say 2 weeks, okay, 2 weeks. Stop, huh? Since Mr. You have, you received the copy?
No, a copy.
Okay,
So let them furnish an extra copy.
accepted notice upon, notice on behalf of the respondent. No formal notice need be issued. However, the petitioner shall serve extra requisite copies, self-furnished extra requisite copies to the respondent during the course of the days.
Lordship.
Okay, stop. Huh? List is matter after 2 weeks. Okay, try. Let us try. Okay.
I'm obliged.
For motion, item number 5.
May it pleases your lordship.
Yes.
Lordship, I am for the petitioner, my lord, for ICICI Lombard. My MSc appeal number 4 of 2022 was dismissed for non-prosecution, and therefore I have filed this restoration petition along with the IA for continuing a delay of 59 days in preferring the restoration petition. Wide order dated 28/8. I have annexed it. My lord, page 11, my lord.
Okay.
Wide order dated 28/8/2023. MSc appeal along with the connected IA was dismissed for non-prosecution. I missed the case for 2 days alone.
So you are filing for restoration.
Yes, my lord.
Will issue notice.
My lord.
This is item 5.
Yes, my lord.
Okay. The petitioner had Learned Counsel, Miss
S. Kakoti, my lord. Sumi Kakoti.
Learned Counsel for the applicant staff. Huh? The applicant filed this application under section 5 of the Limitation Act 1963 for condonation of delay of 59 days in preferring the accompanying restoration petition accompanying restoration petition for restoration petition for restoring the MA appeal.
Yes, my lord. MSc appeal number 4 of 2000.
MSc appeal number
4 of 2022.
4 of 2022, which
Along
was dismissed for non-prosecution on 28/8/2023. Stop, huh? Issue notice returnable by The respondent is
My lord,
private
there are six,
respondent only by
six,
six.
six
4 weeks.
respondents, but respondent number one is representing the 5 respondents.
Okay, respondent number 1 is representing,
1 to 5 and respondent number 6. So there is basically 2 respondents, 1
Two
and 6.
okay, so notice upon the respondent by a registered post with AD card. No. Issue notice upon the respondent, huh? Returnable by 4 weeks. We'll say 4 weeks.
My
Okay, stop, huh? The petitioner shall, the applicant shall take steps upon the respondent by a registered post with AD card within 5 days. You take steps within 5 days,
My lord,
list this matter after 4 weeks. Okay.
my lord, if I pay for a date kindly, any date, my lord.
For 4 weeks means that will be list this matter as prayed for by the learned counsel for the applicant. List this matter on January which date? After vacation?
18, 19.
Hmm? Do we have the date? Calendar? No.
18, 19.
This is 23.
But like the calendar.
Same.
See.
Actually. 18. Okay. We'll say 18.
My
18 January.
my lord,
Okay.
highly request.
For hearing item number 10.
May it please the lordship.
Yes, please. Sir.
My lord, this petition is being converted to petition under Article 227 of the Constitution of India by order dated 2011-2023.
Okay. So this was the order was passed in presence of the respondent also.
My lord, but
What is the then consequences of the conversion?
my lord, this matter pertains to the injunction order. My lord.
Yes.
The trial court issued temporary injunction order in favor of the petitioner in respect of suit claim. However, on appeal by the respondent, private respondent, the appellate court, first appellate court reverse set aside the injunction order. So against that injunction order, I am before this order.
Okay.
So my lord, it has a checkered history, my lord. This on this particular plot of land in 1999, there was a dispute. So my lord, by order dated 13 May 99, my lord, at page 75 of my petition, madam, and next year piece, page 75, and next year piece 70. Page 75.
Just a minute, huh? This page probably,
Page 75.
just a minute. Okay, initially this was filed and application under Rule 32 of the rule.
Yes, earlier it was filed under Rule 32 of the Ministry of Justice and Police in Nagaland. Third Amendment Act 1982.
This has not
Right,
yet,
with
not
section
yet,
115.
not yet been replaced, huh?
CPC.
Amended course title
Manu.
not yet replaced. Okay, yes. The other side is present. Okay, so, any affidavit from your side?
No, Lordship, because,
Not necessary.
not necessary, because all the records are here. We are
Okay.
examining the order.
LCR was called for, yes.
Yes.
Okay. Yes,
So, Lordship, now, this petition is a petition strict only under Article 227 of the Constitution.
hmm,
We proceed accordingly.
yes,
My lord. May I draw your lordship attention to page 75 of the petition, ma'am.
page 75.
75. My lord.
Yes,
Yes, that copy is at page 75A, my lord. Next page, my lord.
yes,
There is my lord. Government of Nagaland, Office of the Deputy Commissioner, Dimapur District, Headquarters, Dimapur Camp, Dimapur, Nagaland. Order dated Dimapur, the 13th May 99. Number given you so and so. It has been reported that Sri Gaidi Boom has wrongly occupied the land covered by part of dark number 113, measuring an area of 00 biga, 01 katha, and 19 lesa at block number 3. Whereas this actual encroachment is covered by part of dark number 98.
just a minute,
Manu.
So you gonna wrongly occupy
Yes,
the land covered by part of dark
dark number 113,
1 and 3.
measuring an area of 00 biga, 01 katha, dash 19 lesas at block number 3. Whereas his actual allotment is covered by part of dark number 19. Next paragraph. The next para will not be relevant. The third para,
This order was passed by Deputy Commissioner,
Deputy Commissioner.
99.
Yes,
And then this, Gaidibong is, who is he?
so my lord.
He's a
it's not
petitioner.
party to this case, my lord. So I'm-
Respondent.
I'm highlighting the matter, my lord. Since this is important because
Then who is Gaidibong?
this is,
Gaidibong, who is this?
he was in occupation of this particular land, which belongs.
He is respondent here in this
No, no.
case.
My lord, I'll come to that. I'll play.
Okay, okay.
Yes. So next, third para, my lord, relevant.
Yes,
Whereas land in question is a pata land belonging to Sri D.Y. Sema by right of purchase, by sale deed registered number SD 14698 dated 7898 covered by dark number 98 113 under pata number 804/64. Accordingly, seen and perused the technical report and the underside comes to a conclusion as under. 1. Sri Gaitipu is hereby directed to occupy the area allotted to him as part of dark number 98 with immediate effect. So my lord, after passing of this order, this Gaitipu he vacated the land and I took possession. Now this same area is, same land is under dispute with the respondent number 3. In this.
this, Gaidibong vacated the lane
In
99,
And
part
I
of
occupied the
that-
land.
dark number 113.
Yes, sir.
And this dark number 1 and 3, after vacation, after Gaidibong vacated, you occupied.
Yes, my lord.
Okay. So you occupy on what, on the basis of what? On what,
My lord.
you occupied this the dark number 113,
Yes,
on what basis?
See, this is on the basis of that salary which was executed between the landowner and myself.
And your name is?
DY Sema, Toshe.
Okay, you are
Y Sema.
DY Sema.
Yes.
Okay. Yes.
Yes, my lord. Now, my lord, I filed a suit against the order passed by the Deputy Commissioner on 19/9/2018. At
Just a minute, DY Sema. Okay, then. You occupied the said land on 2099?
It's a, my lord.
Yes.
So, my lord, what happened in 2016?
2016?
Yes, in 2016, the
No, thereafter till 2016, you were under peaceful possession of
my
the
lord, my lord.
particular land.
My lord.
Okay.
So, my lord, in 2016, the respondent number 3, he enclosed by that same land, which was vacated by Gaitimu. So I lodged a complaint to the Deputy Commissioner. At page 79, that is the restraining order issued by the Deputy Commissioner. At page 79, my lord. It is dated 19 February 2016. Page 79, my lord. Annexure P20. They are it, my lord. This
Page
is all-
79.
Yes,
So,
restraining order, my lord.
hmm.
Dated 19 February 2016, whereas it has been brought to the notice of the undersigned by Sri Toshe Y Sema, dated 18/02/2016, that Sri Kashito Nurumi, son of Sri Bikuto Nurumi, has violated the order issued by revenue dated so and so 13 May 99. My lord, this is in violation of this order, my lord.
Then which order?
That order which I have already pointed out earlier, 13 May 2009, which was issued against Gaitimu.
99.
Yes. Which was issued against Gaitimu. So by taking earth for construction of a building which is viewed as an offense.
Just a minute. Whereas it has been brought to the notice of the undersigned, Dosi Y Sema. Who is Dosi Y Sema?
He is the petition here, brother.
Oh, sorry. DY Sema.
Yes.
Okay, same.
Next.
Just a minute. As well. Sri Kaseto Nurumi is the respondent.
Hello. He is the elder brother of the private respondent now.
Elder brother of private respondent.
Yes. He is no more now, my lord.
So he has violated the order issued 1399 by digging earth for construction of building, which is viewed as offense. And with this office, order memo number so and so. This earlier the patta and this number 80464 is the same that patta 113.
Yes, my lord.
Sorry, dag number.
Yes. Yes.
Okay, for the sake. Restrained from any further development. Okay, he was restrained.
Yes, my lord.
Okay, then,
Thereafter, my lord, right order dated 29 June 2016. Next page, my lord, page 80.
just a minute, huh?
So it was directed for verification, joint spot verification. This order was passed for joint spot verification, but which could not be held. Thereafter, on 30th September 2016, at page 81, my lord.
So the 80 is for joint sport
joint spot
verification by,
verification. That is between Joshua Y. Sema versus number 1, Inaka, that is the present respondent, Inaka V, then number 2, Dr.
who is, which one is the present respondent?
V, Inaka is the present respondent.
Joshua, Inaka is the present
Yes,
respondent.
yes.
How many respondents are here in this case?
One and.
Sole respondent.
State also is there.
Hmm?
State is, deputy commissioner.
Okay, okay. Deputy Commissioner. Inaka is the private respondent here.
Private respondent.
In a matter of land dispute. So, so joint sport verification was not conducted on that day.
Yes, yes. Thereafter, yes, another, by another order, there is next page, my lord, page 81.
Yes.
This is 30th September 2016.
Hmm.
Again, order was issued for joint spot verification.
So this is also and Inaka. Inaka and Dr. Jal.
Jalas is not party here.
Hmm?
He's not a party here.
He is not a party.
Yes.
Why his name has been
It
included?
is just because another property, not in this property.
Hmm?
This is in another property.
Another court
Yes,
means
sir. Different plot, different plot.
Sema versus Sri Inaka V and also to just say. Okay, then
So my lord, even on this subsequent occasion, which was ordered for verification, that could not be taken place.
verification done on this day.
No, it was not done.
Okay.
Yes, my lord. Thereafter, my lord, Deputy Commissioner passed this order at page 43, my lord. At page 43.
Page 43.
Yes,
What is this order about?
my lord, it is order about the same plot of land and by other Pata land, my lord.
Same plot.
Same plot, it is included.
Let
the
us
same plot.
let us just read.
Let me read, my lord.
Yes,
This is dated 19th September 2018.
it's okay. In the matter.
In the matter of complaint petition filed by Sri Toshe Y. Sema.
He's a petitioner.
Yes, he is the petitioner. Regarding claims and counterclaims of a plot of land at Block 3 against Sri Inaka V and another plot of Dr. Talatsu Chase. The restraining order has been issued to all the party concerned by order dated 19/02/2016 with a direction to the land report survey officer Mahmood to verify survey the land in dispute. According to the land report survey officer, by this letter dated 02/04/2016 submitted the report, wherein the disputing parties have been summoned on 13/5/2016 by order dated 10/5/2016. All the three parties appeared and presented the statement and document in support of their respective claims. Yet the spot verification stated above was conducted between only two parties, Sri Toshe Y. Sema and Inaka V. Hence, another joint survey comprising of all the parties was directed for joint spot verification by order dated 11/8/2017 to be surveyed in presence of the magistrate fixing on 5/09/17, and accordingly the land report survey officer by letter dated 28/11/17 submitted the verification report as reported below. And my lord, this is
Okay, so here they probably have clarified that,
this report is,
hmm,
it appears that it is submitted on 28 November 2017.
report, down below is a report.
Report, the purported report by the land report and survey officer.
Okay, what the report
Dibabur
says?
May I read, my lord?
Yes.
So the Deputy Commissioner Dibabur Nagaland, submission, subject submission of spot verification report. Sir, what reference to your office order number so and so dated 11 of August 2017. The spot verification has been done by the surveyor in the presence of RO, ESA Revenue, LRSO, at DB Dimapur and various concerned parties of Sri Inaka, V. Sri Toshe, Vaisema and Dr. Chalachuchase regarding a land dispute. Therefore, aforementioned spot falls under block number 3, Moza number 1 with the original dark number 106 and 113. However, on verifying the ground position it is demarcated on the settlement map, it has been found that plot number 596 is being recorded under the name of Dr. Chalatsu Chase, bearing pata number 270, dark number 106/so, 106/1652, basically in the area of 4 biga, 04 biga 01 kata and 11 desas, and plot numbers 621. My lord, this 621 is the plot of the claim by the private respondent.
Respondent.
Yes, private respondent. And plot number 621 is being recorded under the name of Sri Gaipi Khan, son of Sri Panjuchung, bearing pata number 238, dark number 400, measuring an area of.
Where are you reading now?
My lord,
Where are you reading now?
my lord,
No, plot number 621.
yes, plot number
621 is being recorded
is being recorded
under the name
under
of,
the name of Sri Gaipi Khan, son of Sri Panjuchung,
okay,
bearing pata number 238, dark number 400, measuring an area of 00 biga, 01 kata and 18 lesas. C Inaka B mutated from this dark. Plot number 621. Yes.
and your claim is?
Tomorrow I'll clarify that position.
Hmm?
I'll come to that.
Okay, so this is different, separate.
This is what the survey report says.
Hmm.
It was telling in the name of Capricorn, mutated in the name of V Inaka B. Next page, my lord.
Okay,
Wherein the disputing were summoned on 11/05/18 for final hearing. All the parties attended and presented their individual claims over the plots and submitted documents in support of their claims. That on perusal of the available review reports and supporting documents submitted herein with reference to the land report survey officer report stated above, it has been found thus. That the land under pata number 270 of dark number 106/431 measuring an area of, my lord, this is not relevant for the present matter, my lord. Para 2, my lord.
okay,
Para 2. That the land under pata number 573 measuring area of 00 biga, 01 kata, dash 18 lesas, dark number 753 was initially separated and carried forward from pata number 64 in favor of Srimati Gaithilui by PC number 77/88 D/06041 441 dated 13/10/88 and later sold out the entire plot to Sri Kasiton Nurumi by sale deed registered number SD 378/98/98 dated 14/2/98 and subsequently granted mutation and transferred in favor of Sri Kasiton Nurumi, Seba, son of Sri Vikutu Nurumi, by mutation case number so and so dated 16/02/98, which was again gifted to his biological brother Sri Itaka V, son of Vikutu Nurumi, by gift deed registered number SD 2063/15 dated 21/09/15 and accordingly granted mutation by petition case number so and so dated 21/09/15. So my lord,
The, which one is connected to you? Yeah.
my lord,
Hmm.
this, as per the finding of the deputy commissioner,
Hmm.
the plot of land which is being claimed by the private respondent in this case,
Hmm.
it was stated to be transferred from the name of Srimati Gaithului.
Hmm. So, Gaichuli
Yes.
to?
In the year 1988
Hmm.
and in the year 1998.
Hmm.
Thereafter, the same land is said to be gifted to his younger brother, that is the present respondent, in 2015.
2015? The same land, this land bearing number claimed by the respondent?
This is under doc number 113, my lord. Out of the, but their pata number is shown as pata number 573.
Five, 7, 3.
Yes. In the second paragraph, first line, my lord.
Yes.
And
Yes,
that is doc number-
7, 5, 3.
That is doc number. 753 is doc number.
Okay, 573 is a
Is the
pata
pata
number.
number.
So this pata number 573, dag number 753 is the land claimed by Gaithuli.
That is claimed by now the respondent.
Sorry, claimed by the
private-
respondent.
Yes.
So this land actually is initially separated in the carry in favor of Sri Gaithuli. Hmm.
Whereas in the land revenue survey officer's report, my lord,
Hmm.
which is in the page 43.
Yes.
There, the picture is different. There it is said that plot number 621, which was in the name of Gapi Khon.
Six 21.
Yes,
Is the
ma'am.
name, huh? Yes.
Which was in the name of Gapi Khon, mutated in the name of the present responsible.
Okay, this land, 621
My lord.
mutated in the name of the present respondent.
Yes. Doc number there, it is doc number 400. My lord.
Just a minute. Huh?
Bearing pata number 238, doc number 400.
Plot number 621 was mutated in the name of,
In the name of the respondent, Hidaka V.
respondent is only one, sole respondent.
Yes, sole respondent,
Hmm.
private respondent, no,
Hmm.
not
But-
sole respondent, private respondent.
Okay, but he claims,
This pata bears pata number 238, That
Yes.
is from Pata number 238, my lord.
Plot number 621 is,
From Pata number 238. Dock number 400.
this was mutated in the name of the respondent by this plot number 621 was mutated in the
From
name
which
of the
dock?
present respondent by whom?
By Deputy Commissioner, my lord.
Okay. Okay, so, but then his claim is
My lord.
this was initial, this is the lane mutated in the name of the petitioner.
Yes.
Sorry,
No, no,
respondent,
respondent.
respondent.
Yes.
Uh,
Then the other one. my
Hmm.
lord. Para 2, next page, my lord.
para two.
Yes.
Yes,
So here the mutation is done from the name of Kashito. Yeah, may I read, my lord, the second?
Yes, please.
Para 2, my lord.
Hmm.
Get the land under Pata number 573, measuring an area of 0 biga, 0 K, dash 18 LS. Dock number 753 was initially separated and carried forward from Pata number 64 in favor of Srimati Gauhati Lui, by PC number so and so dated 13/10/88, and later sold out the entire plot to Sri Kasito Nurumi by sale deed registered number SD 378/98 dated 14/2/98, and subsequently granted mutation and transferred in favor of Sri Kasito Nurumi Sema, son of Sri Dipito Nurumi, by mutation case number so and so dated 16/2/98. Which was again, my notice is important, which was again gifted to his biological brother Sri Inaka V.
Just a minute, the respondent is, just a minute.
Respondent number 3, my lord.
Is Inaka,
Inaka V Nurumi.
petitioner is D.Y. Sema. Respondent is Inaka.
Inaka V. Inaka V Nurumi.
Okay.
So, my
So,
lord,
so this is separate plot. 573 is separate plot.
as per document, it is separate.
So, separate from the 621,
Yes, my lord.
separate.
My
So
lord.
this was,
Because the landowners, original landowners, they also separate.
okay, but it was gifted to Inaka, the respondent, by, on 2015. 2015.
Yes. So, my lord, this is, Lordship will be, this thing, surprised to note that gift it was executed on 21/9/2015, and on the same day it was mutilated. My lord, and by this time, brother, that is Sri Kasito Nurumi, he is no more. So it is the duty that has been executed in the name of a dead person. On the same day, mutation also granted.
Kasito Nurumi died on,
My lord,
later on, I think, after the,
let me take your lordship to the written statement of the respondent, prime respondent. Yes. Wait. Yes, page 112, my lord. page 112. This is their written statement. As para B man. Para B.
Yes.
After 22/7/05. That is the date on which the defendant number three's elder brother Kaseto Nurumi expired.
What is it? And thereafter only.
My lord.
Sorry, 2015. This was 2015.
Yes.
And then he died on 2005.
Yes. As per their written statement. This is as per their information.
And just a minute, so which was again gifted to his biological brother Sri Inaka, son of Narumya, by gifted 21/9/15. Kazeto Nurumi expired, but then Kazeto Nurumi has gifted it to.
As per this report, my lord, the gift deed was executed on 21/09/2015. At this point of time, Kaseto is no more.
Kaseto was no more, and then
Yes.
the Kaseto initially gifted it to whom?
No, as per this gift, it is given to the now private respondent. In Akabi.
No, so it says
Yes.
that dated 98 says, na? Dated 98, which was, which,
98 is from Gaidulu. That is from Gaidulu, Srimati Gaidulu. Kaseto mutated from Srimati Gaidulu.
and subsequently granted mutation and transferred in favor of Sri Kaseto Nurumi Sema
In 98.
98. Yeah, this was before, yes, 98, that is possible. Which was again gifted to to his biological brother, Inaka. By, yes. By the time of, you see, and at the time of execution of this gift deed, and as per this, their affidavit, Kaseto Nurumi was no more. You mean to say?
Yes, but this is the finding of the deputy commissioner. This is his order, and this is the finding.
Okay.
And as per the written statement in the suit, my lord, he died, Kaseto Nurumi died on 22/7/2005.
My
But
lord,
this is their finding. Now, para 3,
yes.
this is in respect of the petitioner. As Sri Doshe Y. Sema executed a sale deed with Srimati Maithanlu Rombe, then Patadar of Pata number 64, clearly registered number SD 84/95, dated 31/05/95, measuring area of 04 biga, dash 04K, dash 03 half lesas from dump number 98 and 01 biga, 03 kata and 09 lesa under dump number 113 from Pata number 64. Located at block number 3, and accordingly process was initiated for mutation of the same land in favor of the purchaser Sri Toshiwa Seva, bearing mutation case number so and so 95. Accordingly, notice was issued inviting claims objection, which is reproduced very below.
Who is this Meitenlu Rongmei?
She is the seller of the land which was sold to the petitioner.
Okay.
Toshiwa Seva.
So this was done in the year 1995.
95.
So this land bear number, Patta number 64.
Manu. My lord,
Yes. It was mutated
yes,
in the name of the
dossier wise.
petitioner on
My lord,
date not given.
date is
Reproduce below, I think, where? It's given. 6th June,
no, my lord. The
this is notice.
Pata was issued on 7 July 95.
Where do we find
My
that?
lord, yes, 7 July 95 at page 58, my lord. 58 of my petition.
58.
58. Whether your lordship has found it. No, this is-
58, yes.
yes.
Where do we find the date?
My lord, on the right hand side, mutated and separated from last column, my lord.
Mutated and
Mutated and
separated from.
Pata number 64 to the name
No.
of the dossier Sema on the white case
Okay,
number
okay,
M
okay.
so and so. Dated 7
7
July.
July.
95.
Just a minute, huh? This, this lane is 573, no?
Seven July, my lord.
Yes, yes, no, this is connected to the para 2 of, that is under Pata number
Pata number 573.
573.
Yes.
573. This was gifted to the petitioner. Sorry.
Sold to the petitioner.
On which date? 16. 2. No, no.
My lord, para 2 is the respect of the respondent, my lord, private respondent.
Okay.
Mine is para 3, my lord.
Para 3, sorry. Okay.
My lord.
Yes.
Page 45, my lord.
Mm.
My lord, this is the notice in respect of the land purchased by the petitioner from Srimati Maitrani Company.
And this is notice.
Notice issued inviting claims in objection with regard to the land under process for mutation in the name of the petitioner in view of the purchase made by him from the then owner.
Okay, so purchase, let us see.
So my lord,
Notice is hereby.
notice is hereby given that Srimati Doshe Y. Sema, son of Yataku, a resident of Notun Basti under Rule 50/51 Assam Land Revenue Regulation 1886, applied for mutation of land described in the schedule above or schedule below. The undersigned under Rules 52 of the said rules hereby invite that claims, objections concerning the said land, if any, should be submitted to his her court in written on or before 5/7/95. Schedule of the land, name of the Patata Maitrani Mumbai, village block number 3, Pata number 64, dog number 98, 113, area 443 Desas. SD Khalo Kapo, Additional Deputy Commissioner, Dimapur Nagaland, dated Dimapur the 6th June 25.
Okay, after issuance of this notice, then mutated on
Immediately was-
7/7/95.
Yes. So my lord, now here next para, my lord, after the box, from the above notice issued published by M 452/95 dated 6/6/95, it is pertinent to mention herein that the mutation was processed for an area of only 4 Bika, 4 Katha, 3 Desas under part of dark number 98 and 113 from Pata number 64. Hence, mutation ought to have been granted only for an area of 04B, 04K, 3 Desa under dark number 98 and 113, showing the respective areas under each dark. However, as per the revenue report, the area granted by mutation is number so and so dated 7/7/95 shows that the whole area of 04B, 04K, 03 half LS under dark number only, that is 98, and another additional area of 1 Bika 00 Kata 19 Lesas under another dark number 119/1991, which does not tally with the area mentioned in the sale deed bearing registered number so and so dated 31/05/95, as well as in the public notice and the Jawabandi bearing number 804 issued on 11/07/95 in favor of Doshe Y. Sharma shows the total area of 06 Bika 00 Kata 017 half Lesas. However, in the revenue record, it shows only an area of 06B00K -02 half Desas. Thereby, on meticulous authentications in consultation with the available report, it has detected various anomalies that needed to be rectified. In other words, the mutation granted by mutation case number so dated 07/07/95 needs to be set aside with the liberty to file effects.
So this, there now, this 98 and 113 from Pata number 64 is connected with whose land? Which land?
My land, my lord.
This is your land.
My lord.
Okay, this,
My next page, my lord.
okay. So this says that as per the report, it does not tally
Yes.
with the sale or purchase.
No, my lord. Here, the mistake has been committed by the office.
Okay,
The area under dock number 113. That has not been mentioned in the notice.
Okay,
Otherwise, the dock number 98 area is mentioned, whereas in respect of dock number 113 area has not been mentioned. This is by the office, my lord. And that has been now, after 95, this order was issued in 2018, my lord. After more than 20 years. Now my land pata, that has been set aside, my lord.
okay,
On the next page, my lord.
okay, next page.
46. There is the order dated. Here is the order dated 13/05/99, wherein para 3 reads court. Whereas the land in question is a pata land belonging to Sri Doshe Y. Sema by right of purchase, by sale deed registered number SD 146/98 dated 7/9/98, covered by dock number 98-113 under dock number pata number 804, 64 unquote. It is admitted to the extent borne by the court that Sri Doshi Y. Sema had executed a sale deed with Sri Sapong Chem Sangtam for a plot measuring area of 00 Diga, 01 Kata, S 15 Nesas, covered by pata number 64 under dock number 113, located at block number 3 and registered before the sub-register of this office, right? Registered number SD 146/98 dated 07/08/98. However, the court clearly indicates that mutation was granted in 07/07/95 mutation case number so and so, and accordingly, pata number 804 was issued in favor Sri Doshe Y. Sema. As such, the sale deed executed between Sri Doshe Y. Sema and Sri Sapong Chem Sangtam and registered before the competent authority by so and so dated 7/8/98 as claimed by Sri Doshe cannot be availed down to substantiate his claim over the court of law. Therefore, the order dated 13/05/99 passed by the then ATC is void ab initio. Thus, the order dated 13/05/99 cannot be considered to uphold the natural justice of law. In view of the above observation and finding, the complaint petitions dated NIP submitted by Sri Doshe Y. Sema is hereby dismissed with a direction to allow peaceful occupation by the Patada Sri Inaka V and Dr. Chalatu Chase in the interest of justice. This order vacates the restraining order dated 19/02/2016. Any party aggrieved by this order may approach appropriate forum for resolution of their grievances. So, my lord, the land which has been already mutated in my name, page 50, and pata has been issued, Jamabandi has been issued in my name.
So by this order, your application was dismissed.
My lord, by this order, my mutation has been set aside.
Mutation has been
Yes.
set aside.
And by the same order, the land which is belongs to me under my occupation, against which restraining order was issued to the respondent, private respondent, that has been vacated and allowed him to occupy the land. So, aggrieved by this order, I have filed a suit.
Okay. Yes. Agree by this, with this order.
I have filed a suit, which is civil suit number 5 of 2019, before the civil judge senior division, Dimapur Nagade. And along with the suit, my lord, I also filed application for.
So
granting-
agree by this, you filed what, a suit, where do we find, where we find?
My
Suit.
lord, my lord, my length is at page 25. Annexure A of petition, my lord.
So this was before
Before
senior, civil judge.
just senior division, my lord, Dimapur.
Yes,
Page 26, my lord, post ID.
yes.
Here, the petitioner is the plaintiff,
Hmm.
the state,
Enough,
by
right?
the secretary to the government of now,
Yes.
the department is the
Hmm.
dependent one, deputy commissioner dependent number two,
Yes,
and the private respondent, that is Sri Inaka B. Room is the dependent number three.
hmm. Yes. Hmm.
So my lord, next page. Page 27,
Hmm.
the suit for declaration and reconfirmation of right, title, interest and possession of the plaintiff over the Pata land to set aside order dated 1909-2018, passed by the deputy commissioner, and to restrain the defendant number three from entering into the suit land by granting permanent injunction, etc.
Yeah.
Along with this, I filed the IA civil 98 of 2019 for grant of temporary injunction, my lord. This is IA civil at page 82, annexure B, my lord.
IA4,
This is for
injunction,
grant of temporary
injunction.
injunction, my lord.
Hmm, yes.
So, my lord, respondents also, they have filed their written statement, their written objection in the IA, written statement in the main suit. So thereafter, my lord, hearing on the injunction petition, that is IA 98 was taken up. It was heard by the learned civil judge senior division on 24/01/2020. Which is at page 179, madam. The order, after hearing, the order was passed on 13/02/23.
Hmm. So they file written statement,
Written statement in the main suit, in the civil suit.
as well as in
and
the.
written objection in the IA.
Hmm. Hmm.
At page 179, madam. The order passed by the 179. Annexure H. Yes, may I read, my lord?
So this is in IA.
Yes, IA 98, 2019.
Okay, so
May I,
yes, yes,
may I read, my lord?
yes, this
It is,
order.
yes,
Yes,
order, it is order, date of order is 13/02/2020, order.
yes.
Para one,
Hmm.
Mr. N. K. Litan, the learned counsel for the petitioner, Mr. A. Jimobi, the learned counsel for the opposite party number 3, and Ms. Rongsadena for opposite party number 1 and 2 present. I have heard the learned counsel for the parties and also perused the materials available on record. The petitioner, Sri Doshi Waisema, who is the plaintiff in the civil suit number 5/2019, is praying for grant of temporary injunction and thereby restrain the opposite party number 3, his men, agent, support employees, and servants, etc., from entering, disturbing, interfering with the peaceful occupation, possession, and enjoyment of the suit land during the pendency of the civil suit. Number 3, the brief facts of the case as pleaded by the petitioner are that the suit land measuring an area of 0/01K 18 LS of block number 3, Dimapur town is part and parcel of land measuring total area of 101B01K 14 LS under dark number 116/991, covered by Pata number 804, being purchased from the landowner Patada Srimati Maithanung Romai by registered sale deed number 84/95, dated 3105.95, and is standing in the name of the petitioner as per the Jawabandi issued on 11/07/95, and since then, the petitioner has been in possession, and as per the land Pata Jawabandi issued on 11/07/95, hearing Pata number 804, and the dark number 98/113/991 of block number 3, Dimapur town, comprising the total area of land measuring 0.6 biga 00K 07 half LS. That is to say, under dark number 98, an area of 04B 04K 02 half LS, and under dark number 113/991, an area of 01B 01K 14 LS. It is stated that the petitioner had also purchased a plot of land measuring an area of 0B 011K 15 LS under dark number 113, covered by pattern number 64 of block number 3 from Sri Sapong Jem Sankal by registered sale deed number 14698 dated 07/08/98. However, the mitigation process of this land is still pending due to misplacement of mitigation case report, and in view of the restraining order dated 19/02/2016 issued by DC Dimapur. It is further stated that on the application of the petitioner, the TTC Dimapur by letter dated 15/10, directed the LRS of Dimapur to demarcate land at block number 3 under dark number 98 and 113. According to the surveyor deputed by LRSO, Dimapur verified and demarcated the aforesaid land and submitted spot verification report by letter dated 15/04/99. Thereafter, based on the said verification report dated 15/04/99 of the LRSO, Dimapur, the DC Dimapur passed order dated 13/05/99 and directed Sri Gaitibu, who has wrongly occupied the land under dark number 113 measuring an area of 0B01K 018 lesser at blocks number 3 to occupy the area allocated to him at part of dark number 98 with immediate effect. It is further stated that in the month of February 2016, the defendant number 3 in the name of Sri Kasito Nurumi illegally started digging earth over the suit land belonging to the petitioner.
So who was defendant number 3? Yeah,
present respondent.
present respondent.
Respondent is private
Mhm.
respondent.
Mhm.
Yes. Thereafter, the DC Dimapur issued order dated 29/06/2016, 30/09/2016 for spot verification of the suit land. However, the joint spot verification could not be carried out on 11/7/2016 because of water logging in the same area, and on 07/10/2016 as one of the party, namely Dr. Jalatu Chase, was not present on the spot. On 5/9/2017, the LRSO Dimapur, along with survey team, visited the spot under dispute to carry out verification and demarcation of the land of the petitioner, but failed to carry out verification and demarcation of the land of the petitioner, as Dr. Jalatu Chase was not present on the spot, and also the opposite party number 3 and his supporters disturbed and created commotion at the disputed spot. Therefore, the purported spot verification report dated 28/11/2017 submitted by the LRSO Dimapur is not at all correct, being prepared and submitted without conducting survey and verification of the disputed land. It is further stated that the opposite party number 3 has started claiming the suit land on the basis of the land pata issued in his name. The purported spot verification report dated 28/11/2017 submitted by the LRSO Dimapur and the order dated 19/09/2018 passed by DC Dimapur. It is further stated that the opposite party number 3 cannot claim the suit land on the basis of the spot verification report dated 28/11/2017 submitted by the LRSO Dimapur and the order dated 19/09/2018 passed by the DC Dimapur in view of the following contradictory facts. In the spot verification report dated 28/11/2017 pertaining to the suit land under tag number 113, block number 3, Moza number 1, it is stated to have been found recorded in the name of Sri Wan Kapi Khan, son of Sri Panjung Diary, Pata number 238, tag number 400, measuring an area of 00B-01K-18LS, mutated in the name of Sri Indaka V from this tag. That is plot number 61. Number 2, common 2, the finding of facts relating to the suit land as recorded by the Deputy DC Dimapur in the order dated 19/09/2018 mentioned that the suit land claimed by the opposite party number 3 is covered by Pata number 573, tag number 753, measuring an area of 00B-01K and S18LS, was initially separated and carried forward from Pata number 64 in favor of Guide Theory by PC number 77/80/6041/441 dated 13/10/88 and later on sold out the entire plot to Sri Kashetu Nurumi by Scientific Research number SD 378/98 dated 14/02/98 and subsequently mutated and transferred in favor of Sri Kashetu Nurumi, son of Sri Vikuto Nurumi by petition case number K92/98/11370-73 dated 16/02/98, which was again gifted to his biological brother Sri Inaka B, son of Vikuto Nurumi by gifted registered number SD 2063/15 dated 21/09/2015 and accordingly granted mutation by mutation case number M1094-15/10696-976 dated 21/09/2015. Thus, from the above stated facts, the inevitable conclusion is that the order dated 19/09/2018 passed by the DC Dimapur is unjustified, being contrary to material evidence available or report. Hence, the intense application praying for grant of injunction during the pendency of the main suit. The opposite party number 3 had 5 written objections as well as written statement denying the claim of the petitioner by stating that the land of the opposite party number 3 is covered by Pata number 573, tag number 753, block number 3, Dimapur Town, Moza number 1, and measures 00B-01K-18LS being purchased by his brother, late Kashito Nurume, in the year 1998 from one Gauhati wife of Sri Kapilung and mutated in his name by order dated 16/2/98. After the demise of Kasitu Nurumi on 22/7/05, through family settlement, the land given to the opposite party number 3, white 15, dated 21/09/15 and mutated in the name of opposite party number 3, white order dated 21/09/2015. Thereafter, in the early part of 2016, the temporary structures on the land were demolished and began to work to lay foundation of RC structure. In the midst of this work, a listening order dated 19/2/16 was issued by the district administration. Para 10, that from 19/2/16 to 19/2/19, the opposite party number 3 was not able to raise the structure and incurred heavy loss as construction materials got damaged, and also the land lay idle for a period of about 2 years and 7 months. However, upon issuance of the 19/09/2018, the opposite party number 3 resumed its construction on the land. Foundation was laid and all 28 posts raised. In the midst of this activities, the opposite party number 3 received the order of this honorable court dated 29/3/19. The opposite party number 3 further stated that the petitioner clearly knows that this land is located at different site in relation to the land of the opposite party number 3. However, since the opposite party number 3 and his family refused to sell and or exchange their plots as desired by the petitioner out of shared with the petitioner has filed a suit requested. 11. It is further stated that by the order dated 19/09/18, the revenue authorities came into conclusion that the land of the petitioners lately discovered by different pata and located elsewhere vis-a-vis the land owned by the opposite party number 3, defendant number 3. The order dated 19/09/18 relies on the spot verification report dated 28/11/17. Paragraph 12. The opposite parties number 1 and 2 filed their written statement denying the claim of the petitioner, mainly by stating that the petition has not complied with the mandatory provision of section 80 CPC before filing the instant suit, and as such, the instant suit is liable to dismiss. So also the plaintiff has no longer standing to institute the instant suit against the answering defendants. It is further, paragraph 13, it is further stated that in the Jawabandi annex as annexure P6 of the plate, the total area shown is 06-0-17 and in the report made by the answering defendant, the area reported is 6-0-2.5. Thus, it only shows that the area of 0-1-15 was addressed in the Jawabandi even before it was purchased from Sri Sapong Singh Sambal. As per reports available as part of verification, it is found that the defendant number 3 is in occupation of an area of 00B-01K-18LS under pattern number 573, tab number 753, block number 3. The original tab number covers vast area and individual tab numbers are carried from original tab number. It can be ascertained from the Jawabandi of the plaintiff wherein an area of 01B-0K-14LS are covered by tab number 113/991. Dark number 113 is the original dark and dark number 991 is the new dark. Under number allotted to the plaintiff for this area of 1B-0K-19LS. The original dark number 113 is retained with the first pattern number, which is 64. As such, presently original dark number 113 under pattern number 64 stands in the name of 3, Holitoli Kaihe. As regards to mentioning of the plot number 621 was during the resettlement survey of that area in the year 2001. And that plot numbers allotted. Each recorded land owners whose land was surveyed by allotted plot numbers, and the same is being maintained by the LRSO. The LRSO therefore mentioned the plot number in the spot verification report dated 28/11/2017. The original dark number 113 does not belong to the plaintiff. The land of the defendant number 3 also falls under original dark number 113. The plaintiff is trying to create confusion and take advantage from mentioning of the problem. 621. However, the fact remains that the land of the plaintiff measuring 01B-00K-19LS and the land of the defendant number 3 measuring an area of 00B-01K-18LS falls under the same original dock number 113. Thus, the land of Sri Gaipiko, which falls under original dock number 113, was transferred to defendant number 3. From then, recorded owner Petulu on the stand of Sili. It is further stated that the order dated 1909-2018 was passed on the basis of the spot registration report and various records maintained by the answering defendants. There are no contradicting facts in the spot verification report dated 28/11/2017 and the order dated 1909-2018. Para 14. It is further stated that the sale deed of plaintiff appears to be tampered after its registration. The recorded area of the plaintiff in the record of right maintained by the defendants and in the copy of Gauhati under the custody of the plaintiff differed, and that too under the same pattern number. Answering defendants are the custodian of that report, and thus any time document produced by Pata holder should tally with the reports maintained by the answering defendant. The area of 40-4K S3 half pesa under dock number 98 is not disputed. However, as regards the area claimed by the plaintiff under dock number 113/991, measuring 01B-01K-14 LS, it is totally wrong, and on report the area under dock number 113/991 is only 01B-00K-09 LS. Therefore, the plaintiff is put to strict proof of the same. The plain in its overall reading does not disclose any cause of action against defendants. No reliefs as paid for should be given to the plaintiff and the case or to this case. Again, written statement of the defendant of which parties the plaintiff filed replication denying the contention of the defendants. This court, by order dated 29/03/2019, passed in IA civil number 997/2019, granted leave under section 80 subsection 2 of CPC to the plaintiff petitioner for filing the instant suit, civil suit number 5/2019. Para 16. I have considered the rival submissions made by the learned counsel for the parties and the settled law with regard to grounds of temporary injunction. In Delhi Mata Plus Private Limited versus State of Maharashtra and others, the Honorable Supreme Court held at Para 30, 31 and 37 that interim order is passed on the basis of prima facie findings which are tentative. Such order is passed as a temporary arrangement to preserve the status quo till the matter is decided finally. We issue that the matter does not become either infructuous or a fait accompli before the final hearing. The object of interim injunction is to protect the plaintiff against injury by violation of his rights, for which he could not be adequately compensated in damages recoverable in action if the uncertainty were resolved in his favor at trial. By Anand Prasad Agrawal, so and so. Para 31. Grant of an interim relief in regard to the nature and extent thereof depends upon the facts and circumstances of each case, as no state-taken formula can be laid down. There may be a situation wherein the respondent defendant may use the suit property in such a manner that the situation becomes irretrievable. In such a fact situation, interim relief should be granted. By M. Gurdas versus Raja Rasa Hinjan. Grant of temporary injunction is governed by three basic principles. It is prima facie case, balance of convenience, and irreparable injury, which are required to be considered in a proper perspective in the facts and circumstances of particular case. But it may not be appropriate for any court hold mini trial at the stage of grant of temporary injunction. Right, HM Limited versus Cadbury India, so and Anand Prasad Agrawal. Para 37. Thus, the law on the issue emerges to the effect that interim injunction should be granted by the court after considering all the pros and cons of the case in a given set of facts involved therein on the risk and responsibility of the party, or in case he loses the case, he cannot take any advantage of the same. The order can be passed on settled principles taking into account the three basic principles, that is, prima facie case, balance of convenience, and irreparable loss. In the instant case, it is evident from the 10 Pata Jawabandi dated 11/07/95 and extra P6 issued to the plaintiff petitioner that the land comprising total area of 06 P-00K-17 half LS forwarded by pattern number 804 falls under dock number 19 and 113/991, that is an area of 04B-04K-03 half Nesas under dock number 98 and an area of 101B-01K and 14 LS under dock number 113/991/991, block number 3, Dimapur Town. Admitted the land vessel in the area of 04B-04K-3 half lesser under dock number 98 is not under dispute. That the land measuring an area of 00B-01K-18 lesser under dock number 113/991 is under dispute in the suit out of the recorded area of 101B-01K-14 LS annexure P6. The land in dispute was part and parcel of the recorded area of 01B-01K-14 LS annexure P6. Another plot of land measuring an area of 00B-001K-015 LS under dock number 113 covered by pattern number 64, block number 3, Dimapur Town, standing in the name of Sapong Singh was also purchased by the petitioner by the registered serial number 14698, dated 07/08/98, which is yet to be implemented in the name of petitioner 20. Because of the case revealed that the present suit land was in dispute way back in 1990 and once the Gaidipung and disputed then being settled in favor of the plaintiff petitioner by TC Dimapur by order dated 13/05/99. As such, the petitioner has a practice case to put to trial. Para 18. It is the case of the petitioner plaintiff that the opposite party number 3 for the first time in the month of February 2016 started claiming the suit land on the basis of the then Pata Dhawan dated 21/09/2015. Thereafter, on the basis of the spot verification report dated 28/11/2017 and order dated 19/09/2018. It is evident on record that the spot verification report dated 28/11/2017 of LRS Dimapur and the findings of facts arrived at in the order dated 19/09/2018 passed by TC Dimapur are contracted to each other. The land Pata Dhawan issued as early as 11/07/95 in favor of the petitioner plaintiff and the actual physical possession of the suit land by the petitioner plaintiff for over 20 years cannot be dispossessed on the basis of the order dated 19/09/2018. As such, the balance of convenience is in favor of the petitioner plaintiff. The petitioner being in possession of the suit land for over 20 years cannot be dispossessed without recourse to law. If the petitioner is to be dispossessed from the suit land during the pendency of the suit and after being in possession for over 20 years, then rape, hardship, and irreparable injury will be caused to the petitioner. My lord, the operating part is para 19 next page. Consequently, introductory application serial number 98/2019 praying for temporary injunction is allowed. It is hereby directed that the defendant number 3 shall not carry out any further construction development in the suit land, and the defendant number 1 shall not put any order, issue any fresh order in respect of the suit. The plaintiff shall not demolish any of the structure concerned by the defendant, nor develop the suit land till further cited the suit on merits. IA number 98/2019, civil suit number 5/2019 stands disposed. So, my lord, after this, appeal was filed by the private respondent.
Okay, the respondent file appeal.
Yes,
Okay.
before the principal district judge.
Hmm.
So thereafter, what happened, my lord, it was filed in March 2020. So the first summons was issued to the petitioner for appearance in the appeal case. What happened, your lordship, from March 25, since there was lockdown, the date for appearance was fixed on 9th April 2020. So in view of the lockdown, the petitioner could not take any steps. And he was waiting and anticipating that rest notice would be issued after the court resumed its function. But no such notice was issued. It was only in the month of November 2020 when the respondent he started resuming to consult his house. Thereafter only he came to know that the appeal case has been initiated and the first appellate court has issued suspension order of the impugn order of the trial court. So thereafter, my lord, the petitioner, he files.
Just a minute, where is the appeal, the order in appeal?
My lord, the appeal. Yes, the appeal memo is at page 188. 188, section I.
Hmm, 188. Okay. Yes. Hmm. So where is the order?
The impugn order is at page 251. The order will be impugned with this within petition.
So this order is impugned.
This is under. And then it is
215.
250.
No, 250.
250.
This was, the appeal was contested. No,
My lord, yes.
it was
It
contested.
was yes.
Okay.
So this is the order of the first appellate court. 250, you know, we are it, my lord.
Yes.
His civil appeal is directed against the order dated 13/02/2020 passed by the Learned Civil Judge Senior Division Dimapur in IA 98/2019 arising out of civil suit CS 05 of 2019. Sri Indaka B. Nuruli, that is the appellant, defendant number 3 in the suit, appellant in this appeal, versus number 1, Sri Toshewai Sema, respondent plaintiff.
Okay.
Number 2, the state of Nagaland. Number 3, the deputy commissioner. Appellants, for the appellants, H. Momi and associates. For the respondent 1, NPL Kam and associate. For performer, respondent 2 and 3, Tong Sen La, Shamil, government leader. Date of argument 23/11/2020. Date of order 02/12/2020. Next page,
Yes.
the order, para 1. This is an appeal under order 33/1R of the Code of Civil Procedure 1908 against the order dated 13/02/2020 passed in IA 98/2019 arising out of civil suit 05 of 2019. The present appeal is preferred against the order dated 13/02/2019 passed in IA 98/2019 arising out of civil suit 2019 by the civil judge, senior law and intervention, application filed by the respondent plaintiff. Number 2, the case of the plaintiff respondent in the suit was that the plaintiff purchased a plot of land in 99 measuring 4 biga 4 kata 3.5 acres under dock number 98 in area of 1 biga 3 kata 9 acres under dock number 113 block number 3. Dimapur town covered by Patan 64. 1. from one Srimati Maithinu Rongmei White Saint Jude number 84/95 dated 31/05/95. The plaintiff respondent once stated in the plain that he applied for mutation of the first plaintiff referred to as ADC for the sake of brevity, and White mutation case number M 452/95/3102-04 dated 7/7/95. The aforesaid land was mutated and separated from pata number 64. In Jawabandi bearing pata number 804 on the dark number 90113/991 comprising of total area of 6 biga 00 katha 17.5 paisa. It is an area of 4 biga 4 katha slash dash 3.5 paisas on the dark number 98, and an area of 1b dash 1k and 14 LS on the dark number 113/991 of block number 3 Dimapur town was issued in favor of the plaintiff, and since then he has been in possession of the paid yearly land revenue regularly up to 2018. It was also the case of the plaintiff respondent one that made an application dated 17/05/96 to the ADC Dimapur for demarcation of the aforesaid place. The ADC Dimapur filed letter dated 14/10/96 directed the LRSO and survey officer Dimapur as LRSO for the sake of brevity to demarcate the land at block number 3 under dark number 98, 99, 113 and 1024. Para 5. As per the letter dated 14/10/96, LRSO deputed surveyors and land was demarcated on 30/10/96. According to the plaintiff respondent 1, he purchased another plot of land in 1998, measuring 0B, dash 1K, dash 15 LS on the dark number 103. Covered by pata number 64 of block number 3, from 1 Sapong Sem Chandam, White Saint Jude number 146/98, dated 7/8/98. Para 6. Thereafter, the plaintiff respondent 1 applied to the Deputy Commissioner Dimapur White letter dated 15/08/98 for mutation of the said land measuring 00B-0K1K-115 LS under dark number 103, covered by pata number 64 of block number 3, standing in the name of Sapong Singh Samdai. But the mutation process could not be completed due to misplacement of the mutation papers. He therefore applied again by letter dated 16/01/2017 for mutation and issue of Jawabandi for the plot. However, the mutation process was kept pending in view of the restraining order dated 19/02/2016 issued by the DC Dimapur. 7. It was also the case of the plaintiff respondent 1 in CS 5719 that the spot verification was conducted on his request, and the surveyor submitted the spot verification report dated 15/04/99 to the Deputy Commissioner DC Dimapur, basing on which the DC Dimapur passed order dated 13/05/99, whereby it was stated that 1-3 Kaikipung has wrongly occupied part of the land in the dark number 113 measuring an area of 00B-011K-19 LS at block number 3. Whereas this actual allotment is covered by part of dark number 98, and hence Kaikipung was directed to occupy the area allotted to at dark number 98. Para 8. Plaintiff respondent stated that in the month of February 2016, the appellant defendant number 3 illegally started digging earth over a portion of land under dark number 113 belonging to the plaintiff, and therefore he filed a complaint dated 18/02/2016 to the DC Dimapur, who issued a restraining order dated 19/02/2016. Thereafter, the DC Dimapur directed the LRSO to conduct a spot verification and to submit report. On 5/9/2017, the LRSO along with survey team visited the spot for verification on ground. However, according to plaintiff respondent, the verification and demarcation would not be carried out, as one of the parties, Dr. Sakalu Chasi was not present, and also the appellant defendant number 3 and his support was created for motion and disturbance, and therefore the purported spot verification report number so and so dated 28/11/2017 submitted by LRSO is incorrect, as it is made without survey and verification of the disputed land. Plaintiff respondent one further stated that basing on this report of the LRSO dated 28/11/2017, the DC Mabo dismissed his complaint and allowed the appellant defendant number 2 and Dr. Dalal Chase to occupy the suit plan by an order dated 19/09/2018. 11, being aggrieved by the order dated 19/09/2018, the plaintiff respondent number 1 filed civil suit 5 of 2019 along with IA 98/19 under order 39/1 CPC, praying for temporary injunction against the appellant defendants 1, 2, and 3 to the same name from disturbing and intervening with the peaceful occupation, possession, and enjoyment of the suit land by the plaintiff respondent 1 during the pendency of the suit. According to the learned court below granted injunction on 13/02/2020 after hearing the parties which is under challenge in the present appeal. The appellant defendant number 3 hearing has filed the present appeal under Section 104 and 43 Rule 1R of the Code of Civil Procedure 1908, praying for setting aside interim injunction order dated 13/02/2020 passed in IM number 19/2019 and dismissed the same injunction application. 13, para 13. By the same injunction order dated 13/02/2020, the learned court below allowed the IA 98/2019 by directing the appellant to not hearing of any further concept in the and the state defendant one will not to execute any order or issue any further order in the state of the and the plaintiff respondent one not to demolish any of the structure concerned by defendant 3, appellant give further order of this suit is decided on the basis. Being agreed by the above order dated 13/02/2020 passed in IA 98/2019 by the learned civil just senior division, the present appellant defendant 3 has before this on the grounds. 1. That the learned court below failed to consider that the right of the appellant defendant number 3 is covered by pattern number 573 doc number 753 doc number 3 of the law 1. Whereas the plaintiff respondent 110 is covered by pattern number 804 doc number 98 and doc number 113/991 of law number 3. And even the entries in the report of rights pertaining to the 2 floors of the that the attention of the judge court below was also drawn to the boundaries of the 2 plots, that is the plot of respondent 1 plaintiff and the plot of the appellant defendant number 3 as mentioned in the respective pleadings. The description of the boundaries being completely different. That the appellant defendant has categorically stated that his family has been in peaceful and continuous use and possession of the plot of land covered by pattern number 573, doc number 753 at block number 3 of the Mabu Moza 1. The appellant defendant 3 peaceful possession of said plot has been in the knowledge of the plaintiff respondent 1 also since the year 1990. This fact was also clearly indicated in the order of people's dated 19/9/2018. Para 4. That the appellant defendant 3 states that since he is in possession of his land since 1998, the question of disposition of the respondent number 120 from the street land is not clear. That the learned court below has solely relied on the enrollment of the respondent 120 and ignored the movements of the appellant defendant number 3. 5. Para 5. That the sign for none for the grant of temporary injunction is first and foremost existence of gravity case. Given the undisputable fact that the appellant defendant number 3 and respondent 120 that different force forward by different jawabandis and different boundaries. The plaintiff respondent 1 perfectly failed to establish and work this case. However, in gross error of law and facts, the learned court below allowed the application for temporary injunction. The appellant defendant relies on the case of Kashimar Samastan in another versus Srimad Sudhindra Swami, another report in 2010, 1 SCC 689, where the Honorable Apex Court is dealing with the matter of injury relief, had held that it is well settled that in order to obtain an order of injunction, the party who seeks for grant of such injunction has to prove that he has made out the parameters to go to the trial. The balance of convenience is also in his favor and he will suffer irreparable loss in the injunction is not granted. 6, the learned court below overlooked the fact that the appellant penalty was in possession of this court then from 98. Instead of the claim of the plaintiff respondent that the appellant dependency of vice is then only after the issuance of order. Dated 1909-2018 by the DC Tomorrow was accepted. Surprisingly, this finding of the court below was basis of the issuance of temporary injunction order dated 13/02/2020. 7, that the respondent plaintiff based his claim only on the strength of the Roman issue to him, which is in the report of rights by themselves do not convey right title interest to human property. Reliance would not to have been placed on the one government in the execution of counsel. For that, the applicant number 3 took the categorical stand that he is in possession of this land covered by his government since 1998, and that the land of the plaintiff respondent 1 is a different covered by a different government. This amendment of the appellant defendant set out in his written statement and objection was completely ignored by the lower court. 9, that the state defendant also filed their written statement contending that the plaintiff respondent 1 has no right to claim the land of appellant dependency in as much as the land each of them is covered by a friend. Jawabandi, the state defendants also confirmed that the clearness of the performance right upon by the plaintiff respondent 1 required examination. However, the learned court ignored the same. Yet the learned trial court did not record any foundational basis on how it arrived at the conclusion on any or all of the issues in this, that is the existence of the case. That the learned trial court below completely ignored the fact that the appellant dependency had invested effort and expenditure in developing his land. The huge expenditure incurred by him for the development of his plot was placed for the consideration of the learned trial court. However, all the grounds given were ignored and awarded and baseless and illegal finding that the appellant defendant came into possession of his plot only on the strength of the order dated 1909-2018. That the appellant defendant 3 has stated that in any view of the matter, the order dated 13/02/2020 is bad in law and fact and liable to be passed and set. Paragraph 15. The point for discussion decision before this court is whether the order of the temporary injunction dated 13/02/2020 passed by the learned senior division suffers from any illegality. The learned counsel for respondent 1 plaintiff has at the outset considered that the appeal memo is not supported by the appeal in the court of Geneva. Paragraph 17, that is respondent 1 plaintiff says that the finding in order dated 1909-2018.
So,
Connection 5 is totally contradictory to the report of the LRSO dated 28/11/2017. The report of the LRSO stated that the plot number 621 bearing pattern number 238, dark number 400 measuring area of 00B-1K-18 LS is recorded in the name of 1 Sri Katupong, son of Panju Chung and Sri Inaka be mutated from this dark, that is plot number 61. Whereas in the finding of the DC Dimapur said that Sri Kashito Nurumi bought the land under pattern number 573 measuring area of 00B-1K-18 LS from Srimati Gayatri, which was later gifted to his biological brother Sri Inaka and accordingly mutated. Granted mutation right number M so and so dated 21/09/2015. On 18, the learned counsel for plaintiff respondents further says that the right beneficial report number so and so dated 15/04/99 of LRSO and Excel 316 the LRSO had stated that the court showed that Sri Gaidupung has been allotted a plot of land under dark number 98 but occupied in dark number 113 instead of dark number 98. Therefore, the DC Dimapur passed order number so and so dated 13/05/99, directing Gaidupung to occupy the area allotted to him as part of dark number 98 with immediate effect. In the replication of plaintiff respondent 1 to the return statement of defendant 3, plaintiff had stated that the Suitland claimed by the defendant 3 appellant was vacated by Gaidupung government in compliance of the order dated 13/05/99 issued by DC Dimapur. Thereafter, the plaintiff respondent 1 took possession of the said suit land after it was vacated and paid out for filling, and the land was lying vacant at the time of issuing listing order dated 19/02/2016. Para 19, respondent plaintiff also stated that the restraining order dated 19/02/2016 was issued, was passed because the appellant mechanically started making the suit plan during that time only. He also states that case of the appellant number 3 has various inconsistencies at the same deed at annexure 1 to WS of defendant number 3, appellant is registered on 14/02/98, whereas the application for mutation was made on 16/01/98, much before the same deed was registered, and the Jamabandi was issued on 16/02/98. Another inconsistency which the plaintiff respondent 1 has pointed out is that the Jamabandi in the name of the present appellant defendant 3 was issued on 21/09/2015, by which time the elder brother of the defendant was no more. Para 20. Plaintiff respondent 1 states that he has been in peaceful possession of the suit land since 1995 till the defendant number 3 appellant started digging the earth for his land in February 2016. 21. Learned counsel for plaintiff respondent has relied on several decisions of the Honorable Apex Court and the Honorable Gauhati Court to support his contention. That grant of an interim relief depends upon the facts and circumstances of each case, as no straitjacket formula can be laid down. Yet court has passed an order of injunction having regard to the privacy case, balance of convenience and equal injury, and that the primary object of granting temporary injunction is to preserve the property till the legal rights are asserted. A 1990 and Sierra 440. Sri Vasudev Viswas and other cases.
Leave that.
Sri Amit Kumar Ghosh and others.
Leave that.
Manu, I'll come to Para 22, Manu.
Okay.
Learned counsel therefore submits that the learned court below has considered all the aspects of the case and having found privacy case in favor of the plaintiff respondent 1 and balance of convenience in his favor has granted the temporary injunction by order dated 13/02/2020, and therefore raised that the order dated 13/02/2020 passed by the learned civil judge senior division will be upheld. The Kohima respondent 2 and 3 state respondents have also entered evidence and contended that the same deed dated 31/05/95 relied upon by the plaintiff respondent 1 is the basis for this claim is full of anomalies. As per report maintained by the state attorney, only on the area of 4B-3/3 LS under dock number 98 and another area of 1B00K-19 LS under dock number 113-/991 only a total of 6B-00K-2 LS reported in the name of plaintiff respondent. However, in the sale deed dated 51/05/95, after some corrections for reasons best known to the plaintiff respondent 1, the total area is shown as 6B-2K-12 LS. Further, in the Jamabandi described the same land which is annexed as annexure P6 CS also. The total area is shown as 6B00K-17 LS. Another government will also submit that any land document produced by the Pata holder must tally with the revenue course of the government. However, the area difference in the sale deed dated so and so. The Jamabandi under custody of the plaintiff respondent 1 and the reports of the government is so as sale deed 4B-4K-
Okay, leave that.
So, my lord, I'll come down to the next parameter. The state attorney also submitted that an area of 0B-01K-18 LS was already separated from Pata number 64 by number so and so, dated 13/10/1988 and separated to Pata number 573 in the year 1988 as shown in Jamabandi at annexure 2 to the statement of the defendant 1 and 2 in CS 5/2019. Therefore, this Jamabandi shows that the land measuring an area of 0B-01K-18 LS was already separated from Pata number 64 and to Pata number 573. Only after that, some remaining portion of the area was transferred to Srimati Maithunu Romay by way of inheritance by mutation case number M 181/90/6813/15 dated 02/08/1990 is clearly shown in annexure 2A to the detailed statement of defendant Deep Han into in CS 5/19. Subsequently, in the year 1995, the plaintiff respondent purchased an area of 06B00K -02 half from original mobile. Learned government pleader therefore submits that the order dated 1909/2018 passed by the DC Dimapur categorically states that the land of the appellant dependency was initially separated and carried forward from pattern number 64. Hence, in the finding of DC Dimapur, also as part of this stated that the plaintiff respondent one executed a sale deed with Srimati Maithunu Lombe, the grand patadar, as stated earlier, the dock number 113 under pattern number 64 covers a vast area, and from the same dock number 113 numbers of plots of land has been carried over to the same pattern number. Therefore, the respondent cannot claim that dock number 113 only. The state respondent further submitted that the order dated 1909/2018 annexure 5 to the memo was passed on the basis of the spot verification report and the various reports maintained by the state respondents. The land of the appellant dependently is also very much located within the all tab number 113, and therefore there are no contradictory requests in the spot verification report dated 21/11/2017 and dated order dated 19/09/2018. Argument for decision. The court has considered the rival contentions raised by the loyal counsels of the parties. It is seen that the appeal memo is accompanied by a certificate and Bakalama duty signed by the appellant defendant 3. I have also examined the appeal order 13/02/2020 passed by the Learned Civil Judge Senior Division, Dimapur and IA 98/2019. Addressing out of CS 5/2019 also the lower court report. The settled principle of law regarding temporary injunction has already been referred to by appellant defendant number 3. It is Kasimat Samsan and another versus Srimat Sudhindra Sulsa Swami and reported in 2010 1 SSC, where the Honorable Apex Court in the matter of interim injunction interim review held that it is well settled that in order to obtain an order of injunction, the party who seeks for grant of such injunction has to prove that he has made out a prima case to go for trial. The balance of convenience is also in his favor, and he will suffer irreparable loss and injury if injunction is not granted. Number 2, hence for grant of temporary injunction, 3 factors have to be satisfied, which are existence of prima case, balance of convenience, and irreparable loss. In Dalpat Kumar versus Prarat Singh, AR 1993 SC 276/1992 1 SC 719, Honorable Apex Court explained these 3 factors as follows. Number 1, there is a serious disputed person to be tried in the suit, and that an act on the facts before the court, there is probability of his being entitled to the relief of court by the plaintiff defendant. 2, the court's interference is necessary to protect the party from the species of injury. In other words, irreparable injury or damage issue before the legal right could be established at trial. And 3, that the comparative hardship of mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely to arise from granting it. Number 3, in the light of the decision of the Honorable Supreme Court as referred above, this court would like to examine whether this principle has been followed by the learned tribunal. It is seen that the learned court below had granted the temporary injunction in favor of the plaintiff respondent 1 on the following grounds. A, that a plot of land measuring 00B-01A-050 LS at block number 113, covered by pattern number 64 at block number 3, Dimapur town, standing in the name of Sri Sapong Something was purchased by the plaintiff respondent by Sri Tereswan dated 7/8/1998, which is said to be dated in the name of the plaintiff respondent 1. Reports of the case reveals that the present land was in dispute where the time with 1 Sri Gauhati disputed land was settled in favor of plaintiff in plaintiff responded by the deceased by order dated 13/05/99. Such the plaintiff respondent has advanced the case to trial. B, it is evident on report that the spot verification report dated 28/11/2017 of the of Dimapur and the findings of fact that in the order dated 19/9/2018 passed by the Dimapur are contrary to each other. Yet the Gauhati then Pata issued as early as 11/07/95 in favor of the plaintiff and the actual possession of the suit by the plaintiff for over 20 years cannot be disposed on the basis of the order dated 19/09/2018. As such, the balance of convenience is in favor of plaintiff. D, that if plaintiff is to be disposed from the suit during the pendency of the suit after being in possession for over 20 years, then great hardship and irreparable injury is caused to the plaintiff. The General Trial Court therefore directed that the appellant dependency should not carry out any further construction development in the suit and defendant number 1 and 2 state respondents have not execute any order or issue any order in respect of this. So that the plaintiff was also directed not to demolish any of the structure concept by the defendant, nor develop the suit until further orders or till disposal of the suit and merits. 4. It is well settled that an appeal under Order 43 Rule 1R of the CPC against refusal or grant of application for temporary injunction is an appeal against the exercise of discretion and is said to be an appeal in principle. The appellate court will not interfere with the exercise of discretion of the court of first instance and substance in all discretion except where discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court has ignored the settled principle of law, ignoring grant or refusal of the temporary injunction. 5. On going through the claim of CL 05/2019 and the documents relied upon by the plaintiff, respondent 1, this court finds that the land of the appellant defendant is covered by pattern number 573, dark number 753, block number 3 of Dimapur Moda 1, whereas the plaintiff respondent land is covered by pattern number 804, dark number 98 and dark number 113/991 of Dimapur Moda 3. The state respondents have had written statement in the civil suit 5/19/2019 and also filed written arguments in the present appeal based on the report. There appear to be several discrepancies in the area of land claimed by the plaintiff respondents. 1, as per the report as shown by the state respondent in the annexure 2 and 2A of the written statement in actual possession as per the report, these are the claim of the plaintiff respondent is under. Sale deed dated 31/05/95, 4P-4K-3 half LS under block number 98 and another area 1B-3K-9 LS under block number 113 total.
Okay, no need to read this.
6B-2K-12 half LS. B, Gauhati with plaintiff respondent 1 dated 11/07/95. 4B-4K-3 half on the dock number 98 and 1B-1K-14 LS on the dock number 113 9/991 total area 6B-00K-17 half LS. C, records of Kohima state respondents 4B-4K-43 half LS on the dock number 98 and another area of 1B-00K-19 LS on the dock number 113/991 total 6B-00K-3 half LS. Annexure 7 immediate statement also respondent ACS 5/19. 6, a bare permission of the sale deed basing on which the plaintiff respondent is made to the suit with registration number SD 84/95 dated 31/05/95 reveals that there are many inconsistencies in it. There are land space where the area of land was to be inserted and the area has been inserted by hand and not typed in the sale deed. It is seen clearly by the naked eye that there is overwriting over the area inserted by hand and extended with. Additionally, the word dock number 9910925215, a portion of 106 are sold out to the same person. On the first page of the sale deed also appears to be an addition by different typewriter after the issue of the sale deed. On page 6 of the sale deed also there is writing over the area of land. 7, the state respondents have categorically stated that dock number 113 under Pata number 6 covers a vast area, and under the same dock, numbers of plots of land has been carried to different Pata numbers, and that dock number 113 does not belong to the plaintiff respondent alone. 7, 8. The burden is on the plaintiff to show that there is a prima facie case in his favor which needs adjudication at trial. In the opinion of this court, the respondent number 1 has to first discharge his duty to show prima facie that he is the owner of the state land or that he was in possession. The plaintiff respondent 1 has to prove his prima facie case to the satisfaction of the court, and he cannot succeed on the witness of the case of the defendant only, then the permanent injunction can be granted. However, the plaintiff 1 has failed to show a prima facie case that he is the owner of the state land or that he was in possession. Moreover, prima facie, it appears that the court of plaintiff respondent 1 and the court of appellant defendant 3 are different. Ultimately, the plaintiff respondent have to prove this case by adducing evidence at trial before the lower court below. This court is therefore of view that the learned trial court heard arriving at a finding in the IA 98/2019 that the plaintiff has a prima facie case. Operating portion of page 264. Thus, after considering the matter in its entirety and having regard to the law governing temporary injunction and the facts and circumstances as stated above, this court is of the view that the order dated 13/02/2020 needs to interfere with. As a result, the order dated 13/02/2020, IA 98/2019 is yet set aside, and consequently the IA 98/2019 is dismissed. The civil appeal 1/2020 stands disposal sent to the court of civil suit 5 of 2019 to the court of civil justice. My lord, this is the appeal order, and this is under challenge in this revision civil.
Yes.
My lord, in view of the conversion of the earlier revision petition from Rule 32 and 115 of CPC to Article 227 of the Constitution. My lord, now I would like to make submission on the law point, and I would like to cite some decision whether this revision petition under 227 is maintainable.
So now, resume 2 or what? 2.
Overwalk you with it. Manobe, Rafael, hello, Ogo, Mohan, to the night or you can name it with them. Or sometimes that will be overboard, they have to go in the. For the way, maybe we should stay there. Permanent, there will be good with that, so. Dia bawa itu juga alsi lagi deh. Oh, itu nah. Nah, para aja itu. Ini kasih saya. Ini baju itu sehat dari. Sebenarnya belum diperasa. Sampai ini pun Now it's going to be dog river diet, Pataki diet, school diet, well, very boring for it, morning dog river, all the way dog river, all the way to Pataka, you can do that to become river, dog will not make it to become river. Come here, I have no commercial extra pocket money. So I think that is very kind of. So now that is needed. Pacharam Piji will hire. Last to finance a auto engaged with life. So they each one right for.
Yes,
me this motion.
yes, please.
My lord. May I take your lordship to page 58 of my petition?
58.
58.
Yes.
My lord, this is the Jawabandi Pata and Pata of the petitioner. So, my lord, here in the third column, your lordship, fourth column,
Yes, fourth column.
yes, dark number is.
Yes, yes.
One is dark number 98.
Hmm?
At
One is
column 4.
column 4.
One is dark number 98.
Yes.
The second one is dark number 113/991. My lord, the area in dark number is shown as column 5. 4-4-3.5. Then the next under
4 days, 4 days.
3.5.
Yes, 3.5, 7.
Yes. Then next is 1-1-14.
What does it indicate?
This is the area of the lake.
Area.
Yes.
Okay.
This is 1 biga, 1 kata, 14 lesa.
Okay.
Then the upper one is 4 biga, 4 kata, 3.5 lesa. So altogether total area is 6 biga, 0 kata, 17.5 lesa. My lord.
All 6 big. Okay.
Yes. So my lord, this is issued by the respondent authority way back in 11/07/1995.
7795.
11. My lord,
11.
in the column 4 and 5 down below.
Yes.
This is
Signature. Survey.
Assistant Commissioner Revenue. So here this is 11/07/95. This is signed on 11/07/95.
Yes.
Whereas the mutation was granted on 7 July 95. My lord, next page is page 59. This is the land revenue clearance receipt, which is paid up to, this is the 40-year 2018. Next page is page 60.
What do we call a land revenue clearance?
This is land revenue.
Land revenue.
Yes. This is the receipt of payment of land revenue.
Okay.
Next page, page 60. That is the land
Clearance.
land revenue clearance certificate, which is paid up to 2018.
Yes.
My lord, at page 75A, use that copy.
Yes.
This is dated 13 May 2099. So my lord, a part of this land under dock number 113 belonging to the petitioner here. This was encroached upon by Gauhati. So according to the Deputy Commissioner's order, since the land allotted to Gauhati.
Gaidibung is not a party here.
No. So my lord, way back in 99, after the purchase, way back in 99, the present disputed land was under dispute with this person, Gauhati. The present disputed land, that was under dispute with this person in 99.
Okay. So any record of dispute?
So this is the order, my lord. This is the order issued.
Okay, this is okay.
This is the order.
Yes, yes.
So, my lord, from the bottom, the
Right, right.
second last para. Shri Gaidipung is hereby directed to occupy the area allotted to him as part of dock number 98 with immediate effect. So on the basis of this order, this Gaidipung, he vacated the land. So I took possession of the land. That was way back in 1999.
Where it is?
My lord.
Where it says that Gaidibung has vacated and you have occupied?
I have stated in my petition.
Okay, which para?
My lord, that para 5, page 5 of my petition. May I read, my lord?
Okay.
Para 5, at page 5. That in the plain, it was further about by the plaintiff that the plaintiff also applied for further demarcation of the afforded land. Accordingly, the DC Dimapur White letter dated 15/10/1998 directed the land record and survey officer Dimapur to demarcate the land at block number 3 under dock number 98 and 113. It was further averred in the plain that as directed, the aforesaid land of the plaintiff was verified and demarcated by the surveyor and submitted the spot verification report of the surveyor by the land record and survey officer Dimapur White letter dated 15/04/99 to the DC Dimapur. Accordingly, on the basis of the spot verification report dated 15/04/99 of the LRS of the DC Dimapur pass order dated 13/05/99, whereby it was ascertained that Sri Gaitupung was wrongly occupied the land under part of dock number 113, measuring an area of 00B, 01K and 19 LS at block number 3, whereas his actual allotment is covered by part of dock number 98. Accordingly, Sri Gaitupung was directed to occupy the land, the area allotted to him as part of dock number 98 with immediate effect. It was further averred in the application filed by the plaintiff that Sri Gaitupung vacated the aforesaid land under part of dock number 113 measuring an area of 00B-01K-19 LS at block number 3 in compliance of the order dated 13/05/99 issued by the Deputy Commissioner Dimapur Nagaland. Thereafter, the plaintiff took possession of the said land and carried out earth filling and was lying vacant at the time of issuance of the listing order dated 19/02/2016. So, my lord, by the order dated 19 September 2018, the Deputy Commissioner, in spite of all the documents in favor of the petitioner, issued this impugned order, which is under tenant in the suit. So, my lord, basing on this statement, the facts, the trial court issued injunction order in favor of the petitioner, which was set aside by the appellate court. That is the grievance of the petition. My lord, the suit is pending trial.
There is a stay.
My lord, there is a stay.
Okay.
It has not been tried. Only the injunction issue was decided. Against that injunction order, appeal was filed. And in the said appeal, the order of the trial court regarding injunction in respect of the suit land that was vacated. So against that vacation order, this revision petition has been filed. So, your lordship, now the first issue that legal issue that is involved, my lord, invoking the jurisdiction of supervisory jurisdiction of this honorable court under Article 227.
Yes.
Yeah, pass it over to reference of the lordship. My lord. My lord, I would like to cite a decision of the apex court reported in 2004-6 SCC, page 71. In the case of just one Sakalkar and another versus Hirapat Kumar Mahamay and another. The relevant para is para 7, 10, 11, and 12. May I read, madam? The relevant
Yes.
portion of page 73, para 7.
Yes.
The aforementioned suit for injunction was filed by the respondents at that stage. The learned trial court passed an interim order of injunction in favor of the respondent, where against an appeal was preferred by the appellant. The said appeal, as noticed held before, was allowed. The respondent moved the High Court questioning the correctness of the said order purported to be under Article 227 of the Constitution of India, which has been allowed by the review judgment. Para 10. It is neither in doubt nor in dispute that the jurisdiction of the High Court is very limited. Although the High Court has the requisite jurisdiction, the same must be exercised having regard to the scope and ambit of Article 227 of the Constitution of India. Para 11. The question as to whether the application of Article 227 of the Constitution of India could be maintainable or not has been answered by this court in Surya Dev Rai versus Ramchandra Rai, wherein it was held. 38. Such like matters frequently arise before the High Court. We sum up our conclusions in a nutshell, even at the risk of repetition and state the same as herein. My lord. Para 1. Amendment by Act 46 of 99 with effect from 1/7/2002 in section 115 of the Code of Civil Procedure cannot and does not affect in any manner the jurisdiction of the High Court under Articles 226 and 227 of the Constitution. Para 2. Interlocutory orders passed by the civil court subordinate to the High Court against which remedy of revision has been excluded by the CPC Amendment Act 46 of 99 are nevertheless open to challenge in and continue to be subject to certiorari and supervisory jurisdiction of the High Court. Para 4. Para 4. Supervisory jurisdiction under Article 227 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. When a subordinate court has assumed a jurisdiction which it does not have or has failed to exercise a jurisdiction which it does have, or the jurisdiction, though available, is being exercised by the court in manner not permitted by law and failure of justice or grave injustice as occasion, thereby the High Court may step in to exercise its supervisory jurisdiction. Para 12.
Para 12.
In view of the above mentioned dicta, there cannot be any doubt that the petition was maintainable, but its jurisdiction was limited. Another decision, my lord, which is reported in 2008, volume 4 SEC,
Just a minute.
page 451. My lord, I'd like
Just a
to
minute, huh?
refer
Just
Para
a minute,
52.
just a minute, huh? Bring that one, huh? These copy women also have later on, because you will not be able to carry this. Just a minute, huh? Okay. Yes,
My lord, the next judgment is reported in 2008, volume 4 SEC, page 451, in the case of PK Muniraju versus State of Karnataka and others.
Hmm.
The relevant para is para 22, my lord, 22, 24, and 25. The relevant para is at page 456.
okay,
Narrated, my lord, para 22.
yes,
It is settled law that a writ of certiorari can only be issued in exercise of extraordinary jurisdiction, which is different from appellate jurisdiction. The writ jurisdiction extends only to cases where orders are passed by inferior courts or tribunals or authorities in excess of their jurisdiction or as a result of their refusal to exercise jurisdiction vested in them, or they act illegally or improperly in the exercise of their jurisdiction, causing grave miscarriage of justice. In regard to the finding of fact recorded by an inferior tribunal authority, a writ of certiorari can be issued only if, in recording such a finding, the tribunal authority has acted on evidence which is legally inadmissible or has refused to admit inadmissible evidence, or if the finding is not supported by any evidence at all. Because in such cases, the error amounts to an error of law. It is needless to mention that a pure error of facts, however great, cannot be corrected by a writ. Para 24. It is clear that whether it is a writ of certiorari or the exercise of supervisory jurisdiction, none is available to correct mere errors of fact or of laws unless the following requirements are satisfied. The error is manifest and apparent on the face of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law, and to a grave injustice or gross failure of justice as occasioned thereby. It is also clear that the High Court, in exercise of certiorari or supervisory jurisdiction, will not convert itself into a court of appeal and indulges it. Reappreciation or evaluation of evidence or correct errors in drawing inference or correct errors of mere formal or technical character. Para 25. As observed in Surya Dev Rai versus Ramchandra Rai, the exercise of jurisdiction under Article 226 or 227 of the Constitution cannot be tied down in a straitjacket formula or rigid rules. To put it clear, though the power is there, but the exercise is discretionary, which will be governed solely by the dictates of judicial conscience, enriched by judicial experience and practical wisdom of the judge. Another decision which is reported in 2008, volume
so
14 SEC.
in the present impugn order,
Manu,
in the impugn order,
Manu.
what is your allegation? That whether the grave injustice or gross failure of justice, or how do we exercise this 227?
I would just refer back to the decision of the learned appellate, first appellate court. My lord, at page 263.
Yes.
My lord, page 263, my lord, from the bottom, the fourth line, from the bottom.
Yes.
Ultimately, the plaintiff respondent will have to prove his case by using evidence at trial before the learned court. So, my lord, when the first appellate court has come into conclusion that there is a serious dispute, and the dispute has to be tried and proved by the plaintiff at the trial court. So, my lord, by the usually it appears that the suit has become infructuous.
So you are respondent number 3.
No, I'm the plaintiff there. In
No,
the
the plaintiff
appeal- in
respondent
the
number
appeal, in the
3.
appeal, Respondent 1, my lord.
The plaintiff respondent number 3 here in the appeal.
No, here there is a mistake, it should be 1. Plaintiff respondent 1, it should be 1.
So according to you, this amount to?
This amount to non-suiting the plaintiff,
Hmm?
this amount to the suit becoming infructuous, my lord. Without going into trial, now the injunction has been vacated. Now the respondent can do whatever he likes.
It says that ultimately the plaintiff, you, will have to prove this case by adducing evidence at trial before the land court.
Trial court.
How it becomes infructuous? How it amounts to infructuous?
Because the injunction order which has been passed by the trial.
Yes, that is vacated.
Yes.
Hmm.
There, all the parties are restrained to undertake any diplomatic work.
Yes.
So now, that has been vacated.
Hmm.
Now, this order has allowed respondent to occupy and the suit land.
And then it only direct you to prove your case. You
Yes.
need to
Now I
prove
have
your
to
case.
prove my case, but when the document says everything in my favor,
Hmm.
so vacating the order means that without allowing me to substantiate my evidence
Hmm.
in the trial court,
Hmm.
the suit, the appellate court has ordered, I have to prove it in trial court.
Hmm.
That opportunity has not come to me. Trial has not started, my lord.
Okay. Hmm. Okay. Hmm.
In the same line, my lord,
Just a minute. This is
2008,
okay. Okay. Hmm?
another decision, my lord, reported in 2008, volume 14, SCC, page 58. In the case of Ramesh Chandra
Oh,
Sankla,
no, not this one. 2008.
in the case of 2008 14 SCC, page
Yes.
58. In the case of Ramesh Chandra Sankla and others versus Vikram Cement and others. My lord, the relevant portion is at page 87, para 90. Page
Page 87.
Yes. Para 90, may I read, my lord?
Yes. Hmm.
In para 90. Now it is settled that jurisdiction of the High Courts under Article 226 and 227 is discretionary and equitable. Before more than a half century, the High Court of Allahabad in the leading case of Jodhe versus State observed AIR so and so para 10. There are no limits, fetters, or restrictions placed on this power of superintendence in this clause, and the purpose of this article seems to be to make the High Courts the custodian of all justice within the territorial limits of its jurisdiction, and to arm it with a weapon that could be wielded for the purpose of seeing that justice is meted out fairly and properly by the bodies mentioned therein. Para 19. The power of superintendence under Article 2 to 7 of the Constitution conferred on every High Court over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction is very wide and discretionary in nature. It can be exercised ex debito justitia, that is, to meet the ends of justice. It is equitable in nature. While exercising supervisory jurisdiction, the High Court not only act as a court of law, but also as a court of equity. It is therefore power and also the duty of the court to ensure that power of superintendent must advance the ends of justice and uproot injustice.
Yes. Yes.
Another decision in the same line, which is reported in 2010, volume 2, my lord.
2010.
No, my lord, 2008, 2010, volume 8, my lord. 2010, volume 8.
Okay.
Page 329. My lord, it is in the case of Shalini Shyam Shetty and another versus Rajendra Shankar Patil. My lord, the relevant portion is at para 47 at page 346 now.
Yes.
Para 47 may I read. The jurisdiction under Article 2 to 7, on the other hand, is not original, nor is it appellate. This jurisdiction of superintendent under Article 2 to 7 is both for both administrative and judicial superintendents. Therefore, the powers conferred under Articles 2 to 6 and 2 to 7 are separate and distinct and operate in different fields. Another distinction between these two jurisdictions is that under Article 2 to 6, the High Court normally annuls or passes an order or proceedings, but in exercise of its jurisdiction under Article 2 to 7, the High Court, apart from annulling the proceedings, can also substitute the impugned order by the order which the inferior tribunal should have made. Para 48.
Just a minute. This paragraph which is relevant, the proceeding, but in exercise of jurisdiction under 27. Okay, yes.
Para 48. The jurisdiction under Article 2 to 6 normally is exercised where a party is affected, but power under Article 2 to 7 can be exercised by the High Court so moto as a custodian of justice. In fact, the power under Article 2 to 6 is exercised in favor of persons or citizens for vindication of their fundamental rights or other statutory rights. The jurisdiction under Article 2 to 7 is exercised by the High Court for vindication of its position as the highest judicial authority of the state. In certain cases where there is infringement of fundamental rights, the relief under Article 2 to 6 of the Constitution can be claimed ex debito justitia or as a matter of right. But in cases where the High Court exercises its jurisdiction under Article 2 to 7, such exercise is entirely discretionary and no person can claim it as a matter of right. From an order of a single judge passed under Article 2 to 6, a letters, patent appeal, or intra-court appeal is maintainable, but no such appeal is maintainable from an order passed by a single judge of High Court in exercise of power under Article 2 to 7. In almost all the High Courts, rules have been framed for regulating the exercise of jurisdiction under Article 2 to 6. No such rules appears to have been framed for exercise of High Court's power under Article 2 to 7, possibly to keep such exercise entirely in the domain of the discretion of the High Court. number para 49.
Yes.
On analysis of the aforesaid decisions of this court, the following principles on the exercise of High Court jurisdiction under Article 227 of the Constitution may be formulated. So, my lord, the relevant portion I'll take your lordship to the para G, next page, my lord, page 348. The para G. Apart from the situations pointed out in E and F, High Court can interfere in exercise of its powers of superintendence when there has been a patent perversity in the orders of the tribunals or courts subordinate to it, or where there has been a gross and manifest failure of justice, or the basic principles of natural justice have been flouted. Now, my lord, thereafter, the relevant para K.
49G. Okay,
Para K.
K.
Yes.
Okay.
The power is discretionary and has to be exercised on equitable principle. In an appropriate case, the power can be exercised so modo. Then the next subpara, L.
Subpara
L.
L.
Yes. Next, okay. On a proper appreciation of the wide and unfettered power of the High Court under Article 227, it transpires that the main object of this article is to keep strict administrative and judicial control by the High Court on the administration of justice within its territory.
Okay. Well, what do you want to show here?
My lord, I want to show that this, under Article 227, this court can exercise power so moto, even so moto.
Yes.
Yes. My lord, I'll come back with other relevant decision, my lord. My lord, another decision which is reported in 2010, volume 9 SCC, page 385. This is
Yes.
in the case of casing and others versus Municipal Corporation of Delhi and others. My lord, the relevant para is para 15 at page 390. May I read, my lord, para 15?
Yes.
We have anxiously considered the submissions of the Learned Council. Before we consider the factual and legal issues involved herein, we may notice certain well-recognized principles governing the exercise of jurisdiction by the High Court under Article 227 of the Constitution of India. Undoubtedly, the High Court under this article has the jurisdiction to ensure that all subordinate courts as well as statutory or quasi-judicial tribunals exercise the powers vested in them within the bounds of their authority. The High Court has the power and jurisdiction to ensure that they act in accordance with the well-established principles of law. The High Court is vested with powers of superintendence and or judicial revision, even in matters where no revision or appeal lies to the High Court. The jurisdiction under this article is in some ways wider than the power and jurisdiction under Article 226 of the Constitution of India. Now, my lord, next para 16, my lord. Para 16. The High Court cannot lightly or liberally act as an appellate court or reappraise evidence. Generally, it cannot substitute its own conclusion for the conclusion reached by the courts below or the statutory quasi-judicial tribunals. The power to reappraise evidence would only be justified in rare and exceptional situations where grave injustice would be done unless the High Court interferes. The exercise of such discretionary power would depend on the peculiar facts of each case with the sole objective of ensuring that there is no miscarriage of justice.
So here you want, what you want to show?
My lord, here I want to show you that even the evidence which is already on record, that can be appreciated.
Here in this case, evidence not yet still started. Okay. Yes.
In respect of this Article 227, my lord, the last decision which is reported in 2022 for SEC at page 181. 2022 for SEC. Para 15, my lord, at page 186.
Yes.
My lord, I would like to just consider on the relevant portion from the bottom of para 15, my lord, eighth line from the bottom.
Okay.
Yes. The jurisdiction exercise is in the nature of correctional jurisdiction to set right grave dereliction of duty or flagrant abuse, violation of fundamental right, fundamental principles of law or justice. The power under Article 227 is exercised sparingly in appropriate cases, like when there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion that the court or tribunal has come to. It is axiomatic that such discretionary relief must be exercised to ensure there is no miscarriage of justice. Para 61. Explaining the scope of jurisdiction under Article 227, this court in Estrella Rubber versus Das State Private Limited has observed. So the relevant portion is next page, my lord, at page 187.
Yes.
Yes, let me read from top. Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decisions made within the limits of the jurisdiction of the subordinate courts or tribunals. Exercise of this power and interfering with the orders of the courts or tribunals is restricted to cases of serious dereliction of duty and flagrant violation of the fundamental principles of law and justice or justice, where if the High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that the High Court, while acting under this article, cannot exercise its power as an appellate court or substitute its own judgment in place of that of the subordinate court to correct an error which is not apparent on the face of the. The High Court can set aside or ignore the findings or facts of an inferior court or tribunal if there is no evidence at all to justify, or the finding is so perverse that no reasonable person can possibly come to such a conclusion which the court or tribunal has come to.
Yes.
Now on the question of interim relief, my lord. On the question of interim relief, my lord, I would like to cite a decision of the apex court, which is reported in 2009, 5 SEC, 2009 volume 5 SEC at page 694. Para 21. Para 21 is at page 702.
This is state of Assam. Yes,
May I take my note?
yes,
Part 21. A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decision. An interim order which does not finally and conclusively decide an issue cannot be a precedent. Any result assigned in support of such non-final interim order containing prima facie finding are only tentative. Any interim direction issued on the basis of such prima facie findings are temporary arrangement to preserve the status quo till the matter is finally decided. To ensure that the matter does not become either infructuous or a fait accompli before the final hearing.
any interim direction issued. On the basis of those plan. Yes,
Another decision reported in 2009, volume 10 SCC. At page 388. This is in the case of Janit Mata Plus Private Limited versus State of Maharashtra. My lord, the relevant para is para 30, 31, and 37. Para 30 and 31 is at page 397.
yes,
Yes, ma'am. Para 30. Interim order is passed on the basis of prima facie findings, which are tentative. Such order is passed as a temporary arrangement to preserve the status quo till the matter is decided finally, to ensure that the matter does not become either infructuous or a fait accompli before the final hearing. My lord, the object of the interlocutory injunction is to protect the plaintiff against injury by violation of his right for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. Para 31. my lord. Grant of an interim relief in regard to the nature and extent thereof depends upon the facts and circumstances of each case, as no straitjacket formula can be laid down. There may be a situation wherein the respondent's defendant may use the suit property in such a manner that the situation becomes irretrievable. In such a situation, interim relief should be granted. By M. Gurudas versus Saranjan and Sri Devi versus Muralidhar. Grant of temporary injunction is governed by three basic principles, that is prima facie case, balance of convenience, and irreparable injury, which are required to be considered in a proper perspective in the facts and circumstances of the particular case. But it may not be appropriate for any court to hold a mini trial at the stage of grant of temporary injunction. Well, the next para 37, next page at page 399. Para 37. Thus, the law on the issue emerges to the effect that interim injunction should be granted by the court after considering all the pros and cons of the case in a given set of facts involved therein on the risk and responsible party, or in case he loses the case, he cannot take any advantage of the same. The order can be passed on settled principles taking into account the three basic grounds prima facie, that is prima facie case, balance of convenience, and irreparable loss.
Yes.
My lord, I would like to set another decision, my lord. Which is reported in 2010 volume 2 SEC at page 142. Para 22. Para 22 at page 153, my lord.
Yes.
May I read, my lord, para 22? The ratio of the above judgments in that is that once the court of first instance exercises its discretion to grant or refuse to grant relief of temporary injunction, and the said exercise of discretion is based upon objective consideration of the materials placed before the court and is supported by cogent reasons, the appellate court will be not to interfere simply because on a de novo consideration of the matter, it is possible for the appellate court to form a different opinion on the issues of prima facie case, balance of convenience, irreparable injury and equity. So, my lord, as per this decision, my lord, the appellate court ought not to have interfered with the order of the injunction order of the trial.
Yes.
Now, my lord, another decision in regard to interim relief, my lord, which is reported in 2012 volume 1 SEC, page 735.
Yes. Mm.
735 page, my lord, in the case of Makers Development Services Private Limited versus this West Valaya Industrial Research and Development Center.
Yes.
The relevant para is at para 11, page 737.
Yes.
It is settled law that while passing an interim order of injunction under Order 39, Rules 1 and 2 of the Code of Civil Procedure, the court is required to consider three basic principles, namely A, prima facie case, B, balance of convenience and inconvenience, and C, irreparable loss and injury. In addition to the above mentioned three basic principles, a court, while granting injunction, must also take into consideration the conduct of the parties. Para 12.
Yes.
It is also established law that the court should not interfere only because the property is a very valuable one. Grant or refusal of injunction has serious consequences depending upon the nature thereof, and in dealing with such matters, the court must make all endeavors to protect the interests of the parties.
Yes.
Another decision which is reported in 2013, volume 9, SCC, page 221.
Relevant one or two decisions enough, actually. Relevant one or two decision is enough.
My lord,
Yes.
it is para 17. The relevant portion will be, my lord, at page 229. At page 229, from the fourth line, madam. From the fourth line.
Para 17.
Courts therefore will have to venture to decide interim matters on consideration of issue.
From fourth line.
My lord,
Para 17.
para 17, madam. The relevant portion is at page 229
Okay.
in para 17.
Okay.
From top, my lord, fourth line. Courts therefore.
Yes.
Yes, courts therefore will have to venture to decide interim matters on consideration of issues that are best left for adjudication in the full trial of the case, of the suit. In view of the inherent risk in performing such an exercise, which is bound to become delicate in most cases, the principles that the courts must follow in this regard are required to be stated in some detail, though it must be made clear that such principles cannot be entrapped within any straitjacket formula or any precise laid down norms. The courts must endeavor to find out if interim relief can be granted on consideration of issues other than those involved in the main suit, and also whether partial interim relief would satisfy the ends of justice till final disposal of the matter. The consequences of grant of injunction on the defendant if the plaintiff is to lose the suit, along with the consequences on the plaintiff where injunction is refused, but eventually the suit is decreed, has to be carefully weighed and balanced by the court in every given case. Interim relief within which amount of pre-trial degrees must be avoided wherever possible, though experience has shown that observations and clarifications to the effect that the findings recorded are prima facie and tentative, meant or intended only for deciding the interim entitlement of the parties have not worked well, and interim findings on issues concerning the main suit has had a telling effect in the process of final adjudication. It is here that strict exercise of judicial discipline will be of considerable help and assistance. The power of self-correction and comprehension of the orders of superior forums in the proper perspective will go a long way in resolving the dangers inherent in deciding an interim matter on issues that may have a close connection with those arising in the case. So, my lord, the injunction order which was granted by the trial court, that was a well-written order, taking into consideration all facts and all legal issues, my lord. That is the golden principle, that is the prima facie case, balance of convenience, irreparable loss. My lord, the same plot of land that was in issue in 99, that was settled, the person who was in occupation is vacated. Thereafter, there was no dispute. Only in 2016, February, private respondent, he was appointed person. Basing on that, we lodged a complaint to the Deputy Commissioner. The restraining order was issued by the Deputy Commissioner on 19 February 2016. Thereafter, demarcation, spot verification was supposed to be conducted. That was not conducted, and by the purported order of spot verification submitted by the land record and survey officer dated 28/11/2017. Basing on that, the Deputy Commissioner issued the order that is dated 19/9/2018. My lord, now the appellate court, when the defects, the findings of the Deputy Commissioner was pointed out, the learned appellate court opined that the plaintiff has not proved his case. He has not proved his prima facie case, balance of convenience, irreparable loss. Pointing out the weakness of the respondent and the order that is not in advantage of the plaintiff. My lord, when the defect of the order passed by the Deputy Commissioner, which is under challenge in the suit, when those defects are pointed out, the learned trial court took into consideration that aspect. Because the same plot of land was in dispute in 99. After 99, no dispute, only in 2016. The private respondent came into picture. The restraining order was issued without conducting spot verification on the basis of the purported spot verification report dated 28/11/2017. Deputy Commissioner passed order that also contradicting. My lord, land record and survey officer report says that the plot of land which the respondent 3 is claiming is under plot number 621. which was in the name of Gaipur Gong, with pata number 238, dab number 400. That is the report of land record and survey officer. Competent report. Now, the deputy commissioner took consideration of that report. On the other hand, another stand is that this disputed land under draft number 113 was initially notated in the name of one Gaituli, Srimati Gaituli. Subsequently, it was purchased by the brother of the respondent in the year 1998. Then, thereafter, it was gifted in 2015 to the private respondent number 3. So, my lord, this aspect of the matter and the report of the land report survey officer, it is totally contradictory. There the pata number is different, here the pata number is different. Here the dump number is different, here the dump number is different. Now they are claiming with this two different versions, one version of the LRSO, another version of the deputy commissioner. This is totally contradictory. So basing on this, the deputy commissioner passed the order allowing him to occupy his land, and that land is mine. Whereas my pata mutation, that has been set aside. My lord, by issuing injunction order, my interest in the suit property was protected. All were directed to maintain status quo. Even myself, I am not supposed to interfere in that plot, disputed plot, as per the decision of the trial. Now that trial court's order has been set aside by the appellate court. Now there is no status quo. If that is the case, my lord, then the effect of the order of deputy commissioner is not interfere. In view of the appellate court order, the report of the LRSO, which is reflected in the order of the deputy commissioner, that stands. The order of the deputy commissioner stands, and these two plots mentioned by the LRSO is different. The owner was also different, and another plot which was mentioned by the deputy commissioner, this is also different. These two different plots, normal, with different owner, the previous owner, different owner, with this stand, they are interfering in my property. That interference,
all these properties are identifiable.
man,
Different properties, what you say is identifiable.
yes, man.
Okay.
Now they know where is their plot. They are claiming my plot. And this was already settled in my favor in 99. That small portion, which is adjacent to my land. Your lordship, now, as per the decision of the apex court, interim relief has to be given on the basis of the settled law to prove a privacy case, balance of convenience, irreparable loss. My lord, this plot of land, which is about 5,472 square feet, which is within my land. This same property was in dispute in 99. That has been done away. In 2016, he came into picture on the basis of that land pata obtained by his brother from Srimati Gaituli, said to be purchased by him in the year 1998. That was a very interesting, my lord. If I point out this, then they will say that the witness have been, I am taking shelter on the witness of their case. No. The said it was related on 14 February 1998. Pata was issued on 16 February 1998, 2 days, within 2 days. This gift deed, which was purported to have executed in 2015,
Right.
that was after the death of the brother
Okay,
who died in 2005.
yes, yes.
And that gift deed was executed on 21st September 2015. On the same day, Pata was issued. As per the Assam Land Regulation Act rules 1886, 1 month notices. By doing away all these things, they got the help. Now, in my case, it was the mistake of the office, not my mistake. They have mentioned the area of.
In that pata, your lane is covered? No.
It is covered.
Then have you challenged that one?
Pardon?
Have you challenged that one, that patta
I have the next one.
annexed? No, have you challenged
Which
earlier? The patta which you, in the patta issued to the respondent, and as per you, in that patta, your lane also covered? No.
It is not covered.
Acha.
Yeah, they are coming with. the
Just
network,
encroach, okay,
trying to
physically.
come over my land.
And, okay,
Yes.
okay.
So, madam, that is the case, and in spite of the observation of the first appellate court that yes, appeal under order 43, order 14 rule 1R, it is only on principle. Though it has been observed, opined, but in a reverse manner, without protecting the parties in the issue, my interest, without considering that I have already established my entitlement by proving prima facie case, the balance of convenience in my favor. My lord, if the respondent is allowed to continue with the work, the irreparable loss will be caused to me, which cannot be compensated in terms of money. It is my land, madam. So on these facts, the lower appellate court erred in vacating the temporary injunction order.
So now status quo order was passed. Status quo as
After
of now is maintained.
Yes,
maintained.
yes.
Okay. Hmm.
After by this court, status quo order was issued.
Okay. Anything else?
My lord, with any clarification,
Okay. Yes.
May I please, your lordship?
Yes.
Lordship, I am for respondent number 3. The respondent number 1 and 2.
Yes. Respondent number 3 is Inaka.
Yes, the private respondent, my lord. And-
So respondent number 1 and 2,
Are the state respondents,
1 and 2. Okay.
the state respondents, ma'am.
Yes.
And lordship, my friend and me, we have an agreement that we just agreed that
Okay.
I will submit first.
Okay. Okay.
I'm the person whose land is being claimed by the plaintiff, madam, and against which the plaintiff wants his title to be declared by the trial court. In this plaint, the land that is mine is claimed by the plaintiff, and he wants title over the land, and that's why the suit has been filed. The suit has been filed primarily for declaring title, his title, the plaintiff's title, over the land under which has been in my possession since the year 1998. Initially, in the name, under the possession of the predecessor in interest, that is my late brother, my late elder brother. And after he died in the year 2005, the land was bought by my elder brother in the year 1998, not 99, man. Even before that, that order which has been referred to, Gauhati, Lordship has the petitioner said one Gaitipung. Initially, it started with that, my lord, today, Gaitipung. One person, Gaitipung, had been in possession of this land. And this person was asked to be vacated by an order in the year 1999. And thereafter, the petitioner took over. That's how, that is the submission.
Oh.
And even before Gaitipung, even before the order 1999, my elder brother had purchased this land from somebody else. I'll show everything, my lord. And then my elder brother died in the year 2005. I'm from the Sumi tribe, Sema. Lordship, us in tribals after the death, no gift was made before he died. After he died, my lord, he was unmarried. So after he died, our father, we had a family meeting, and this portion of land was given to me. The land that belonged to my elder brother, the family gave it to me. On that basis, my lord, in 2015, I applied for mutation, and the land was mutated in my name. That was in 2015. Now, my lord, that is how I came into occupation and ownership of the land. And in 2016, my lord, and lordship, just the crux, the background, my lord. After that, I'll go in detail. In 2005, when my elder brother bought this land from one Gaitilu, lordship, I'll come to that review afterwards. When my elder brother bought it from one Gaitilu, one Mrs. Gaitilu, there was already a Assam type house in that land, on that land. And my brother was enjoying the rent.
In the land in question.
Yes. And after my brother died, my family, my father, we were enjoying the rent from them. And in 2015, after it was mutated in my name, because through the family settlement, I inherited property. It was given to me. Then after that, my lord, after that, I started enjoying the rent. And then in 2016, I wanted to undertake a construction. I wanted to build a house. I've started digging the pits, the foundation, laying down the foundation. That's when the plaintiff invited me and my brother, us, for purchase of the land. He wanted to purchase the land. We flatly refused. And we started construction, laying down the foundation to construct a building there. And that's when the complaint was made to the deputy commissioner saying that we have encroached in his land. And that's how the restraining order was passed in the year 2016. After the restraining order, my lord, I have not been able to undertake any construction. After the DC passed the order, dismissing his complaint, then I again continued with the construction. I've erected pillars. All the photos are here, my lord. And then again, the temporary injunction order was passed. I had stopped. And then I went in appeal, my lord. Then in appeal that was vacated. Temporary injunction was vacated. And thereafter, they have filed this present revision. Now, my lordship has seen that this application has now been converted to an application under 227. And lordship has already seen that, yes, 227, my lord, the powers are very limited. Limited in the sense that whether the lower court has refused to exercise jurisdiction when there was jurisdiction, or exercise jurisdiction beyond its powers. Or, my lord, the errors are such that it can correct errors, no doubt, but not just mere errors. Errors must be such that it must be apparent on the face of it. It must be self-evident, my lord. It must be perverse. Just to establish an error of fact or law, a long-drawn argument should not be made. So that is the law laid down by the apex law regarding proceedings under 227. So, my lord, now, injunction, we all know, my lord, that three golden principles, yes. But the first and the foremost is the principle of the plaintiff, the person who comes to the court, must clearly establish a prima facie case. Even if the other two ingredients of balance of convenience, irreparable loss and damage to the plaintiff, even if those are established, my lord, if the plaintiff is unable to establish that he has a prima facie case, my lord, the court will refuse. Now, my lord, in the plaintiff in his plane, just relying on his plane, Lordship, I will not even rely on the documents for the time being, on my documents filed in my WS. Just on the documents filed by the plaintiff along with his plane, Lordship, discrepancies, inconsistency are so apparent. Instead of establishing a prima facie case, my lord, it shows the discrepancy, it shows the manipulation, it shows how records have been concluded. Therefore, my lord, it was rightly the interim injunction, the temporary injunction was rightly vacated by the first appellate. It could not have been granted in the first instance. So that is my mistake. So, Lordship, if I can just go to the facts now. Lordship, may kindly come to the. Yes. Lordship, may kindly come to page 25. 25 is the thing. And the relevant page, my lord, paragraph 3, page 28. I'll start paragraph 3, my lord.
Yes,
Yes, Lordship, may.
planes, no?
Yes, plain, paragraph 3 of the plaintiff. That in the year 1995, the plaintiff purchased a plot of land measuring an area of 4 bighas, 4 kathas, 3.5 lectures under dark number 98, and an area of 1 bigha, 3 katha, 9 lectures under dark number 113 of block number 3, Dimapur town, covered by pata number 64. Lordship, may kindly note pata number 64 from the landowner Patada Srimati Mitanlu Rongman. Lordship, may kindly note them. White registered cell number such dated 31/5/1995. This is the first statement, my lord. From whom? Not from Gaitipu, my lord, but from Mitanlu Rongman. And covered under dark number 98 and 113 and pata number 64. Now, Lordship, you can see again, same statement at paragraph 8, page 36, my lord. Now, which is the suit land? Lordship is
Para
para 24.
24.
24. May I read this one?
Yes.
The plaintiff states that as the right title and interest and possession of the land measuring an area of 4 bigha, 4 kathas, 3.5 lectures under dark number 98, and an area of 1 bigha, 1 katha, 14 lectures under dark number 113/991, block number 3, covered by pata number 804, including the suit land, lawfully rests with the plaintiff. So, my lord, this land is the suit land is covered by dark number 98 and dark number 113/991. Lordship, the dark numbers keeps on changing. Pata numbers keeps on changing as it becomes smaller and smaller. So, Lordship, categorical statement from where the land has come, from where he had purchased the land. Now, Lordship, may I again see
So, where this dark number 98.
dark number 98 and includes an area of 1 bigha, 1 katha, 14 lectures. And dark number 113.
Yes.
My lord, under 98, 4 bighas, 4 kathas, 3.5 lectures. Under 98, 1 bigha, 1 katha, 14 lectures. Dark number 113. So that's what he says, my lord. And then covered by pata number 804. 804. Now, Lordship, may kindly, your Lordship is seeing it.
What different? Is there any difference here?
No, Lordship, I'm just establishing first his statement.
Okay.
I want to show his statement, then take your Lordship to the documents and show the inconsistency.
Okay.
The discrepancies. Lordship, I can see paragraph 15.
Plain.
Plain. Page 32. And Lordship, may kindly see here a very magistrates that the plaintiff states that defendant number 3 at no point of time own or possess the land. Lordship, may kindly see own or possess the land at no point of time. That's the allegation, that I never possess the land, I never own the land. Measuring an area of 1 katha 18 lectures under dock number 113 of block number 3, Dimapur town. On the other hand, the plaintiff has been in continuous occupation, Lordship, has been in continuous occupation and possession of the aforesaid land, being part and parcel of dock number 113/991, covered by Pata number 804 since May 1995. The aforesaid land claimed by the defendant number 3, measuring 1 katha 18 lectures, which falls under dock number 113 and 991 of block number 3, Dimapur town, Moza, is hereinafter referred to as the suit land. So, Lordship, the suit land under dock number 113/991, and it has never been under my possession. It has all along been in their possession since the year 1995. Now, Lordship, if that was the case, why go to the DC in the first place? That if I was never in possession, why go to the DC and restrain me from developing that land, my lord?
The allegation is that you encroached upon his land.
But he says it's continuous possession. Now, so he's saying I've encroached. But my lord, 2016, the complaint was made. Anyway, Lordship, now Lordship, the schedule and the boundary. Page 15.
Yes. Yes.
39, madam.
Okay.
Lordship, the schedule of the land is described. 1 katha of the suit land, madam, schedule of the suit land. 1 katha 18 lectures and part of dock number 113/991 covered by Pata number 804, block number 3, standing in the name of the plaintiff as per Jamabandi. So this land is, Lordship, this land is standing in the name of the plaintiff in terms of the Jamabandi issued on 11/7/1995. That is the statement. That means this land, this suit land, is included in the Jamabandi issued to the plaintiff and is covered by 113, dock number 113, Pata number 804, and it measures 1 katha 18 lectures. That is the statement. And Lordship may kindly note this boundary description, because Lordship, this land I'm claiming, the land that the plaintiff is claiming, is not the land that which is under my possession. It's totally a different land. Based on a pata for a different land, he's coming and claiming my land. And that's what has been found by the DCOs. So Lordship may kindly note the boundaries. Lordship, and then Lordship, kindly take the trouble of also taking page number 121. You can compare this, 121.
121.
Yes, 121. Just to compare. And
Yeah.
then Lordship, everything will become clear initially, from the very beginning itself. Lordship, 39 and 121, because 121 is my written statement.
There are 21 of your written statements.
Yes, my lord. Now, bottom, my lord, this in the written statement, I've given the boundary of my land. And Lordship, the boundary given by the plaintiff is at page 39. The boundary by the plaintiff of the suit land, my lord.
Northeast, southwest,
Yes.
yes.
Now, Lordship, if your Lordship sees, not pata land of the plaintiff. Lordship has found that pata land of the plaintiff. Now, east also pata land of the plaintiff. South also pata land of the plaintiff. West also pata land of the plaintiff. So according to the description given by the plaintiff, my lord, the entire land of the suit land is surrounded on all these sides by the land of the plaintiff, my lord. Now, Malik, kindly come, my lord, what is the boundary that of the land that I'm holding, my lord? Page 121, my lord.
Yes.
On the north, my lord, towards the north, land of the plaintiff,
Hmm.
admitted, my lord.
Just a minute.
Towards the south, road from Bamake, police point.
Just a minute. On the north, yes, below, north, lane of the petition,
Yes, lordship has found,
yes.
and road from the Bamake, then, my lord. On the next page, my lord, towards the
On the
east,
south is road from
yes,
road,
south. Road from
it's
Bamake,
different, huh?
police point, yes.
Road from Bamake Police Point,
To
North
Bamake,
is, only north
Yes.
is plaintiff, okay.
yes. Then, my lord, 122, page. East, my lord, towards the east.
So
Land
the
of what?
east is a lane of somebody else,
Yeah, somebody else.
west also
Also
somebody.
land of somebody else.
So this is
Only on
only
the
one,
north.
only on the north side,
Yes, yes, my
it
lord.
is connected with
Yes,
the plaintiff.
yes, my lord. And there's a map also, my lord, given by the surveyor. Page 143, 143. 140. 145. no? Lordship may kindly see the surveyor map at page 145. And again, Lordship may kindly take the trouble of quoting
One 143, just a minute, 143,
145.
145. 145 is map.
Is the map.
Okay,
Prepared by the
which one is the land in question, disputed land?
Lordship may kindly see with that it's line showing the
Hmm?
A/626, my lord. Here,
Just a minute.
Lordship has found that
A/62,
621.
621,
That is the suit.
621, the middle one, okay,
That's the suit then, my lord.
621,
Yes.
620, and then,
That
the,
portion dotted my boundary with that dot boundary, my lord.
no, dot is your boundary.
That is the suit land. This is
Boundary.
the
No,
A/A/621.
there is, the next to that is also sorry, not A, it's A slash
A/621.
621, this is the,
This is the suit land.
okay,
This is
so
the land, which the plaintiff is claiming.
this,
Now, Lordship,
was drawn by,
survey, my lord, survey of Nagaland,
Survey.
the map showing, yes. By the
so
land
when
record-
this was drawn,
Land record and survey officer, my lord,
2017.
year 2017. After the dispute started. On the, on the verifications ordered by the DC, my lord, spot verification.
Oh, this is a part of the verification
Yes,
report,
Yes, it's part of the, and this is a document by them, my lord.
just a minute, and then which one, from this,
Yes, now Lordship
So-
may kindly see the map, the boundary.
boundary,
Boundary description.
description, yes.
What we, Lordship may kindly compare with the description that I've given, page 121. Where it tells with my description or with
Yours
this
is at
description.
121, okay. So.
On the north, I say, my lord,
Nah,
land of the plaintiff.
lane of the plaintiff, yes, not
On north land of the petitioner plaintiff. Here, my lord, north,
plaintiff,
north, there's a land. Now, there's a land, my lord, 621. There's a Nala also.
621 is a lane, 621 is a lane of plaintiff,
621 is the land of the plaintiff. That's what I'm saying, on the north, land of the plaintiff.
okay,
Then, my lord, on the south, I said there's a road.
yes,
There's a road, my lord.
north,
Lordship may kindly see on top, north,
yes, Nala,
Nala, north, there's a Nala. Just adjacent to that, there's a Nala, then the land of the plaintiff, my lord.
okay,
Then east, Lordship, I said, land of Holy Toli,
just a minute.
page 122.
East is lane of Holy Toli,
Lordship may kindly
Yes.
compare.
yes,
Toli.
okay, okay,
And I
Holy
said
Toli.
on the west, I said, Hai Pang Ming Ping. Lordship may kindly,
Hai Bang,
Yes.
Hai Bang,
west, Lordship may kindly come
Yes,
to
yes.
145.
okay,
Then I said on the
south is
south, I said there's a road.
Burma Road.
Yes, Lordship may kindly see road, approach road.
Yes,
So this is the boundary. Actual boundary of the land, which was also been which also tallies with the survey reports.
northeast, west east, Haiban, okay.
No, so therefore, my lord, I
The
was
map showing the area claims and counterclaims by city. The association. Minaka, block so and so. Resettlement block 621 and. Okay, so this,
so that is what,
hmm,
that is the one, that is discrepancy.
just a
my lord.
minute, just a minute. This was a part of a report submitted on
Yes. 1, 4.
when was the order passed or when DC passed an order?
Lordship, the disease order,
This is order when?
the impugn order,
Yes, yes,
19
earlier
February
impugn order before the trial court,
19 February 2016.
16.
Yes, and this has been subsequently again submission of the report on 28 November 17.
Then this is not the part of that,
Yeah,
this
not of,
is,
but with reference to the office order dated session 11th of August 19. A spot verification was ordered.
spot,
143, Lordship may kindly read CAC to the Deputy Commissioner. This order was passed in 2018, my lord. 2018.
this
The
is order,
impugn
this
order,
is,
19
this is order,
September 2018.
this is order,
Yes.
okay. So this was a submission of a sport verification, okay, so this 2511. Submitted by LRSO.
Yes, ma'am.
So after and this sport verification was done on the basis of the direction given by the deputy commissioner.
ma'am.
Okay, just a minute. What is this? Okay, survey report. And we can. Yes,
So, my lord, the first discrepancy there.
yes.
And
Mm.
one major discrepancy again, my lord, the basis from where he inherits the right. There is some, yes, how he says he inherited the right. According to the plaintiff, my lord, the petitioner, the land, the suit land is part and parcel of doc number 113/991 under pata number 804. As per Jamabandi issued on 11/7/95. Lordship has gone through that relevant paragraphs that I've shown. In this paragraph, he says the suit land is part and parcel of a Jamabandi issued on 11/7/1995.
Para 21.
Lordship, that has been said in paragraph 3 also, page 28. And in paragraph
21. Yes.
at page 36, paragraph 24 also, the same as we said, Mano repeated.
Page?
Lordship, may kindly note down the page. Page 28, paragraph 3.
28.
8. Lordship,
Para 3.
yes, ma'am.
Yes.
Then, Lordship, here also is clearly said that the land is part and parcel of, is a part of doc number 113. Under pata number 80. Here the pata number has not been said, but in the subsequent paragraph. And then Lordship has read that.
Page?
Again, my lord, may kindly go to page 36.
Yes.
Paragraph 24 again, my lord.
Yes.
Part and parcel of doc number 113/991. covered by pata number 804. So the
So this covered by pata number 64 in para 3 and then para 24, pata number 804.
has become, that means after initially it was under 64. Lordship will go to the relevant pata after this. I'll take your lordship. to the
Okay,
relevant.
okay.
But just showing the statement, man,
Mhm.
that this land belongs to pata number 804 under duct number 113. Lordship, we'll just try to remember 113, my lord. It's simple, duct number 113.
Yes,
So part and parcel of that land.
but Dag number 113 is, I think, in all, his
Yes.
environment is all the same.
Now, lordship. So this Jamabandi, this pata was issued to him on 11/7/95.
Yes,
Now, whose land was it before that? Let's first go to page 58, the pata, Jamabandi. This is the pata, my lord, issued on 11/7/95 in favor of the petition.
yes,
Now, lordship, can you see? Pata number, my lord, new pata number, first column, 804.
yes.
Please.
804
Yes.
is, just a minute,
Yes.
page
804.
24. Para 24 is at page 20. Eight zero four.
Yes, ma'am.
804 is
The patata is, my lord, that is the
pata number.
pata number.
Yes,
And the
804.
patata is Doshe Y Sema, that is the petitioner, plaintiff. And now, my lord, there's two plot of lands, one under 98, duct number 98. First one is 98. And it measures 4 biga, 4 katha, 3.5 lectures, according to this Jamabandi. And the second one is, the second duct is 113/991. It measures 1 katha, 1 biga, 1 katha, 14 lectures. Now, my lord, lordship may kindly see from where did he get this land? From whom did he purchase, according to this pata? Lordship may kindly see the remark column, the last column.
Yes,
Mutated and separated from pata number 64. Lordship has found it, madam.
yes,
Mutated and separated from pata number 64 to the name of Sri Doshe Sema, that is the petitioner, white case number such and such, dated 7 July 1905. So it was mutated and transferred from pata number 64.
okay.
So lordship, now, this
So-
land,
So that is why earlier it was 60.
yes, ma'am.
Okay,
Now, this land, prior to the petitioner, was prior to becoming a part of 804, was under the pata number 64. Now, who was the owner, my lord? May kindly see Jamabandi at page number 55. Now,
yes,
before the petitioner purchased this land, this total area belonged to, was a part of pata number 64,
yes.
page 55, my lord.
Hmm.
New pata number 64, lordship may kindly see there are two owners, not one. This is the most crucial part, man. There are two owners. First is Srimati Mitanlu Rome. And she owns the land under duct number 98. Lordship has found it.
Yes,
Mitanlu Rome, but she's the she's the owner of the land under duct number 98, my lord. Area of each duct, 4 biga, 4 katha, 3.5 lectures. So 4 bigas, 4 kathas, 3.5 lectures under duct number 98 of pata number 64 belong to Srimati Mitanlu Rome as per the Jamabandi at page 55, which is a document of the plaintiff, mother. This is not a document given by me. It's a part of the plaint. And lordship may kindly see the second owner. The second owner is one Sri Sapungshan. Now he owns a land measuring 1 biga, 3 kathas, 9 lectures under duct number 113. Lordship is clear. So, my lord, there are two owners. The land under Dark number 113 is not owned by Methenlu Rongmei, my lord, but one Sapongshen. And he owns 1 Bika 3 Kathas 9 lectures. Now, Lordship, so in order to buy this land, these two persons must sell it. Because it is claimed that entire land under Pata number 64 has been purchased by the plaintiff. And it is included in Pata number 804 after his purchase. Now, Lordship may kindly come to the sell it at page 47.
Yes,
47.
yes.
Lordship, this is the sell it based on which the land is claimed by the plaintiff. Lordship, may I read this?
Yes.
This is executed on the 30th of March, 1995, between Srimati Methendu Rongmei, daughter of such and such, address is given, and Sri Dosha Y. Sema, that is the plaintiff petitioner, such and such. Now, the relevant portion, whereas the seller, here too is the rightful owner and possessor of the land bearing Pata number 64, measuring in area 4 kathas, 3.5 lejas, under dark number 98, no problem, my lord. Jamabandi shows that she's the owner of the land under dark number 98, and 1 Bika 3 kathas 9 lejas under dark number 113. My lord, this is wrong. She's not the owner. The revenue records given by the plaintiff himself does not show that under dark number, the land under dark number 113, Methenlu Rongmei is not the owner. Someone else's name is shown, my lord. One Sapongshen's name is shown. Lordship may kindly come. Lordship may kindly take this page 47, and also, my lord, page 55. Then,
where is the seller? Here is the rightful owner and possessor of the land and area. And the dark number 113 situated Dimapur. No, this is under whose possession?
now, Lordship, what this cell list says, Methenlu Rongmei, my lord, is the seller.
Yes.
Methenlu Rongmei is the seller. And as per this cell list, by this cell list, the land was sold to the petitioner, my lord. This cell list claims that Methenlu Rongmei is the owner of the land under Pata number 64. And Pata number 64 includes land under 2 dark number, my lord. Under 2 dark number. Lordship has seen
98.
98 and 113.
113.
113, my lord. So Methenlu Rongmei claims that she is owner of both the land. Right, Lordship?
Yes.
But if you look at page 55, my lord, she's not the owner of both the land. She's owner of only one.
98.
98 only. So did she have the authority to sell the land under 113, my lord?
113 is Sampongchen.
Yes, my lord.
So this was
This is the sale deed on the basis of which the petition is claiming.
this was 95, and then the sale deed was executed in the year
95.
May 95.
Yes.
So this was also May 95, same date.
Which one? Same day.
Same date.
30th May.
This Jamabandi was also issued in
Yes, my lord.
31/5/95.
Jamabanti also issued on 31/5/95. The same thing that is being claimed, alleged against me on the same day again. Sell it, Jamabanti on the same day.
Yes, what do you want to show here?
What I wanted to show, my lord, that the petitioner is claiming that he has purchased this land from Methenlu Rongmei, sell this, and through this sell deed. And this sell deed shows that Methenlu is claiming that she's owner of the land under both the dark numbers. Whereas the revenue records, that's the Pata, which was produced by the plaintiff himself, discloses that no, it is not right, it is not correct. Methenlu Rongmei is just the owner of the land under dark number 98, not 113. And the suit land falls under 113. And Methenlu Rongmei did not have the right to sell it, my lord, in the year 1995 because she's not the owner. This is solely relying on the documents produced by the plaintiff, my lord. Discrepancy, my lord. Instead of disclosing a prima facie case, the documents of the plaintiff, it discloses discrepancies, inconsistency.
This 113,
Yes,
the owner of the dog number 113 is Sampong Chem.
yes.
So now here,
Now,
by this sale deed,
she
my
claims-
family sold it.
she
And
claims-
then, so what you want to show this?
What I want to show is that Metinlu Rongme, my lord,
Yes.
who is not the owner of the land under duct number 113, who is
Okay,
claiming.
okay, if she, supposing if she purchased Metonli.
Well, then, lordship, then the land should be recorded in her name in the Jamabandi. The land should have been recorded in her
But
name.
in
the-
any case, it doesn't show it's yours.
Lordship,
So does it show that it is yours?
no, it doesn't show,
Hmm.
because my lord, what I'm saying is,
Hmm.
I will come to my own documents.
Yes,
afterwards.
yes,
I'll come to
that is,
I'll establish my right,
hmm.
how I can, but my lord, first, he's claiming for a temporary injunction, my lord.
Yes, yes,
For that, he has to have a prima facie case, my lord,
yes, yes.
and prima facie case. was-
Whether this has been reflected in the order
Which one, my lord?
of the trial court?
Oh, this, they have skipped, those
These
was argued.
discrepancies has been pointed out by the
This has been, no, this has been argued, my lord.
argued,
argued.
not pointed in the,
Not specific.
not covered in the order.
discrepancies, there are discrepancies. That's what
Okay.
the appellate court has said.
okay.
And the trial court ignored it, my lord. Were ignored. Trial court did not take all this into
In your written
consideration.
statement also, this was not pointed out.
Lordship,
Whether this was pointed out in your written statement,
in my written statement, my lord, this,
because in that case, they have to show that how they have obtained.
yeah, lordship, that
How
written
it came into-
objection has been filed.
Hmm.
Objection to the IA has been filed.
In the objection, whether
Yeah,
this has been pointed out.
Lordship, then see,
Okay.
let's go through once again.
Hmm.
But there are discrepancies in the play. There has been pointed out, it has been simply said that they don't have a prima facie case.
Okay.
There's no prima facie case because it only discloses discrepancies, inconsistencies, no prima facie case, in short one.
Okay.
And before the appellate court, yes, this has been argued, my lord. Before the appellate court, I appeared personally. So
Okay.
this was placed, my lord,
Hmm.
discrepancies. And the trial court also, I mean, the first appellate court also has reflected that there are discrepancies. There's no prima facie case.
Okay, okay.
So, lordship, clearly, the document, the first document, the basis of the petitioner, the plaintiff, that he purchased the land, suit land based on this. This is the sale deed. This is discloses that the seller did not have the right to sell this land. And these are not my documents, my lord. So again, my lord, coming next, my lord, then,
No, just a minute, huh?
yes,
So, because after this,
yes,
13,
yes.
subsequently, kindly see page 58.
Yes,
Okay.
because
Hmm.
page 58 is after the purchase.
So no, not 58, the
55,
Jamabandi of
55.
55. So SEMA 98. It will go SEMA. No, page 58,
Yes, lordship,
this is Jamabandi for
for the petition,
petitioner
after he purchased.
after he purchased,
Based on the sell deed, madam, based on the sell deed, he applied for
based on a
petition.
sale deed.
Yes,
Hmm.
and land was mutated and this Jama body was
But
issued.
who issue, Jamabandi is issued after verification only,
Should be, my lord, actually.
Hmm.
Should,
and then giving an opportunity
should
to
be,
the
yes, my lord,
neighboring
yes, my lord.
possessor also.
Some
So,
land revenue.
but in
regulation.
any case, it was issued to the plaintiff or the petitioner. The Jamabandi,
To the plaintiff, my lord, to the petitioner, yes.
yes.
Because, my lord, I was not in the picture at that time.
Okay.
My brother bought this land only in 98. And how I bought it, from where I bought it,
Okay, please
I
come
will
to
show.
yours, then.
But here, even his basis, the foundation, my lord,
Mhm.
the foundation is
Right.
there's a big defect there.
Hmm.
Now, my lord, may kindly come to page 57. Again, such a big discrepancy here also. The appellate court, my lord, did not simply vacate the order. After seeing all this, and even the DC, this present DC, the impugned order which has been challenged in the plain,
57.
57. This is also another document filed by the plaintiff. This is a notice. My lord, Lordship knows, Assam Land Revenue Regulation, 1886, my lord. It requires notice before mutation, transfer of land. Now, my lord, a notice was given after they purchased the land, after the petitioner purchased the land from this, by the sale deed, my lord, by the sale deed in 95. Notice was issued, and this is the notice, my lord. And this is the plaintiff's own document. This is notice dated 6 June 1995. And Lordship may
Okay,
kindly see-
purchased on May, in the month of May. Notice was issued in the June.
June 6. No, Lordship? may kindly-
Yes, please.
And Lordship, I'll not take your Lordship to all, just the relevant portion. Schedule of land, schedule of land.
Yes,
Name of Patata, Lordship, Patata only is one. Sapong say name is not there. Metinlu Rongmei, block number 3, Pata number 64, my lord, no problem. Dump number 98, 113, no problem, my lord. But area, my lord, Mekalisi, 4 bika, 4 kata, 3.5 lectures only. Notice is given only for 4 bikas, 4 katas, 3.5 lectures only. But Lordship may kindly come to that page, number
3.5, and not for the 1 bigger one.
Yes,
Okay.
absolutely.
Mm,
That's what I want.
Okay.
Notice also given, it's a statutory notice, my lord. Statutory notice under section, I'll come to the relevant portion also, a statutory notice,
Hmm.
yet only this much is mentioned.
Hmm.
So, and I'm also disputing that 113 part only. This also says suit land is under 113, and under 113, 1 bika, 1 kata, 14 lectures.
No, whether this notice is issued before issuance of the Jamabandi?
Yes,
Or-
last 6, Jamabandi is issued on, it was given on.
Sorry, that was in July.
Yes, July.
Okay.
Now, notice is in June, my lord, 6 June.
But then at the time of granting,
Yes,
so these 98 and 113 covered, and then
area is,
area also covered.
area no, not the entire. Area no.
No, in the Jamabandi
Yes,
for
yeah,
of
Jamabandi
the
is covered.
petitioner, 98 and 113.
Yes,
So 443.5 and 114 is also covered.
yes.
So total is
Total area is
6.
6. No, Lordship, another. This is
Yeah.
a public notice.
Yes.
They just mention only one portion of the land. And the land was being
Where
placed-
where is the notice page?
page 57.
Hmm?
57 notice.
57. So okay.
So Lordship, there also another discrepancy, my lord.
Yes.
And this is like at the cost of repetition, my lord. It's a
Mhm.
statutory notice, it's a public notice.
Yes.
Then Lordship may kindly come now. There's another cell deed at page 65. This is also
Page 60.
65. Now this suppose say comes into the picture. But when, my lord,
This is sale deed.
yes, cell deed and my lord between this date of execution, my lord, on this day, on 28th day of July 1998, my lord, July 98.
Yes.
28th July 1998. Lordship, Sapongchen Sanctum. Lordship, that person whose name, who was the owner of the land under dock number 113,
Yes.
page 55, my lord. That person. Now, in 1998, a sale deed is executed, whereas with the petitioner, my lord, for a land measuring dock number 113, under the one covering pata number 64, one katha, 15 lectures. Now, lordship. Why? Option. Now, lordship, if that land was sold in 95, entire land was sold in the year 1995, why another sale deed? That's what the DC says, my lord.
Yes. So
That's what the DC also
now the
says.
sale deed was prepared in 98. So this is the land show 139.
See page 60, 50, now page 47 becomes relevant, page 55 becomes relevant, page 65. These 3 pages has to be compared. Why selling it again for the second time?
Okay.
Only, my lord, because some mischiefs were sought to be. Because by this time, my lord, by July 1998, my brother had already purchased the land from the true owner. Now, mischief is sought to be created. Now back for a land which has already been sold in 1995, mutation down, my lord, another sale deed is being executed. And that's why the DC says, my lord, in the appeal. Why? How can a sale deed sell a land which has already been mutated in 1995?
Yes. Yes.
Yes. So, my lord, now this basically, my lord, are the glaring discrepancies, inconsistencies, which is apparent from the plaintiff's own document. Instead of establishing a prima facie case, all this discloses discrepancies, which
In the impugn order, this has also not been reflected.
No, it's
Okay.
not specifically. No.
Okay.
Specifically, no. Just that no prima facie case.
Okay.
Discrepancies only that matter. But, lordship, instead of disclosing a prima facie case, if you look at it, we find that there's this discrepancies. No prima facie case now. Lordship, may kindly come to my case. How did I become the owner of this? My lord, my WS is at page 110.
Yes.
110, my lord. And I think, my lord, instead of narrating, it's important to read, for me to read some few relevant paragraphs, very short paragraphs, my lord.
Okay.
Lordship, may kindly come to 111. Just
Yes.
yes, ma'am. May I read this?
Yes.
6, paragraph 6 almost, 6. May I read the sub-paragraph?
Yes, please.
In the year 1998, the defendant number 3's elder brother, late Kasheto Nurumi, purchased a plot of land measuring about 1 katha, 18 lectures, covered by pata number 573, dock number 753, block number 3 of Dimapur Moza, from one Srimati Gaitaluman. This is important, this name, Gaitaluman.
Purchase a plot of land measuring around. This is your land.
This is my land.
Covered by pata. This is pata different.
Yes, ma'am.
Dark different. Okay. Dimapur Moza from Srimati Gaitalu.
The purchase of the said property was through a sale. cell deed dated 15/1/1998, executed on 16/1/1998. So by an application dated 16/1/98, the defendant number 3's late brother, that is my lord, apply for mutation and of the said property into his name. Therefore, by order dated 16/2/1998, in petition case number such, the land purchase was transferred into his name, and Jamabandi has been issued. Lordship may kindly see the Jamabandi at page 1636. 136 is the Jamabandi issued in the name of my brother's favor in the year 1998. Yes, Lordship.
136. Yes.
138. Yes, 138.
No, 138 is respondent.
136, I'm sorry. Lordship, let me just read the paragraphs at 111, then take your Lordship to the documents. That will be more convenient for your Lordship.
100.
Yeah?
Yes, yes, please.
Yeah, then my lord, 112. Page 112.
Yes.
B, that on the land, some thatched houses have been constructed along with an Assam type house. The tenants were residing in this structure and they began paying rent to the defendant number 3's late brother.
Yes.
That when the land was mutated in the name of the defendant number 3's late brother in the year 1998, there was no protest from any quarter whatsoever, including the plaintiff. He began enjoying peaceful possession and occupation of his land, along with rents and profits arising therefrom, from 1998 till his demise on 22/7/2005. At the cost of repetition, there was no lack in hindrance or obstructions from any quarter, including the plaintiff, in relation to the land herein above mentioned, during the lifetime of the defendant number 3's late brother. D, after 22/7/05, that is the date on which the defendant number 3's elder brother, Kashida Nurumi, expired, his father took charge over the property. Through a family settlement, it was decided that the land could be given to the defendant number 3. Pursuant thereto, on the application of the defendant number 3, by order dated 21/9/15, in mutation case number such, the land was transferred in the name of the defendant number 3 and Jamabandi issued thereof. E, my lord, next page. In the early part of 2016, the defendant number 3 made plans to construct a permanent structure on the land. In furtherance thereof, the temporary structures standing thereon were demolished. At this juncture, the plaintiff entered into the picture and summoned the defendant number 3 and his father to his residence at Nutun Basti, Timur. The defendant number 3's father and elder brother Kotoho and Viketo went to meet the plaintiff, whereupon he demanded that the land be sold to him or exchanged. The offer of the plaintiff was flatly rejected, much to the consternation of the plaintiff. Since the purpose of the meeting was futile, the defendant number 3's father and brother left. F, my lord. The defendant number 3 began working on the proposed structure. He leveled the land, dug a total of 28 feet. In the midst of this work, he received a restraining order bearing number such dated 19/2/16 from the district administration. This order issued at the instance of the plaintiff restrained the defendant number 3 from any development activity. The basis of restraining order was that the land which the defendant number 3 was developing belongs to the plaintiff and is covered by Pata number 804/64, doc number 98, 113 respectively. On receipt of the first restraining order, the defendant number 3 ceased the construction activity on the land. Lordship, on the revenue side, inquiry into the dispute began. The revenue authorities conducted spot verification. The exercise in this regard finally resulted in issuance of the order dated 19/9/18. By the said order, revenue authorities came to the conclusion that the plaintiff is covered by different pata and located elsewhere vis-a-vis the defendant number 3's pata and the land owned by him. The order dated 19/9/18 relies on a spot verification report bearing number such dated 28/11/17. The said letter has enclosure, a survey report, and a trust map. Now, Lordship, another relevant paragraph, my lord. How Lordship may kindly come to page 119. 109.
So, what I will do, It's probably it'll take more, and then for me also, little more understanding required,
Yes.
is required. So we'll keep it as a part hard,
Yes.
can we?
Yeah, of course.
Because largely have been heard. So we'll fix another date
Yes, ma'am.
where we'll complete the hearing. Of hard the other side, the petitioner side, and then yours up.
Yes.
We'll keep it as a part hard.
Of
So
course.
on that day, I'll have a few questions, queries, and then we'll finish off hearing. After vacation? Just a minute. Okay. Mr. Come, and counsel for the petitioner is present. Mr. For respondent number 3. And Miss for additional senior government advocate.
Additional AG.
No, additional AG is also present for respondent number 1 and 2. Okay, stop. Huh? The matter will only say that partly heard. Okay.
Yes.
Yeah. So matter may be listed after vacation as a part heard. Yeah? Okay. As a part heard matter. Huh? Oh.
Obliged, ma'am.